All right, Mr. Howie. And counsel, you're on this side.
Oh,
How
Your Honor, how you doing?
are you doing? You're looking fabulous.
Thank you very much.
Thank you.
Not a little weight though. I couldn't have, I grew out of my suit. I would have wore a suit,
Let me just tell you, you are dressed very appropriately.
Thank you.
Some people need to take note.
Thank you, ma'am.
All right. So on this case, there's supposed to be a case manager.
And Judge, I've got documentation from Mr. Howie. I have not provided that to the pro tem judge because I just received that from Mr. Howie. But I'm happy to go ahead and scan that and give it to her.
Oh, yes. Attorney Perez,
Yes, ma'am.
the court has been presented with a document that shows that Mr. Howie does have a case manager now. Defense can scan that in the system for you. If you could give that to the coordinator, she will send it to her right now.
Fantastic.
I have extra copies.
Oh, we're good. No, they're just nothing to get. She's on.
Let me put this in here. All right, Ms. Abrams.
Judge, I received a report from Mr. Howie's CSO, and it appears that Mr. Howie is doing everything that he needs to do with his probation at this time. He's reporting as instructed, and she really doesn't have any concerns. She is asking, however, that maybe we just do, since he is back at home, maybe just to ensure that he is in compliance and, make her check out all of her items on her list, that we do field visits once a month for 3 months.
Okay. So then we'll alter, could I see what is his length of probation?
It was a 2-year extension. He was rolled over from deferred to regular
Mm-hmm.
and he was sentenced to 4 years probated for 2. And I think it's up in October,
In 2028.
Okay.
28. I don't know.
All right. So here's the thing. Whether or not you're off for probation in October is 100% depends on you.
28, Judge, not 26.
28.
Yes.
Let me see does anybody have his his probation file? I'm just trying to see the length of his probation. When he was placed on probation, the length of his probation.
Probation is completed October 15th of 2024.
But how long has he been on probation before he was adjudicated?
And he was placed on the third for 4 years.
All right. So depending on how well you do, because I know that a lot of your issues, some of them are issues that are not within your control, right? And I know that there is a stigma attached to mental health, and some of that's not within your control. However, depending on how well you're doing, the court will consider termination depending on how well you're doing.
God bless you, ma'am.
All right. So between now and October, you need to show me that, one, you're going to stay in contact with your case manager, that you're going to follow all of the rules and regulations, okay?
Yes. I was going to ask you, is there any way in the near future that I can find my own doctor, or I just have to be in compliance with the court and stay with the mental?
It would be best for you to confer with your counsel on that and speak to probation on that, okay?
Okay, thank you.
But again, we're trying to see about stability. And if you move from doctor to doctor,
There's just certain medications that they don't issue at the healthcare center downtown that my other doctor did. That was my only concern.
all right, well, just talk to your attorney about it and talk to the doctor downtown about it. Okay,
Yes, ma'am.
all right, any other questions?
There we are.
All right, what we're gonna do, Ms. Abrams, if we can do an update on this case in a couple of months, or when do you recommend? All right. we'll come back in August to see how he's doing, all right?
Fantastic. Thank you.
Judge, thank you very much, Judge. You have a blessed day.
You too, Miss Ferguson, I need a date in August. All right.
I've enjoyed the Boston Camp Flowers.
Yeah.
I told you, it's a man of my words.
Oh, thank you so much.
Blessed day.
You too.
She just signed the receipt.
All right, thank you, Attorney Pettis, for appearing.
Thank you. Will y'all just email me the date, the next date?
It's
Or-
August 10th.
Okay.
And it'll be the same login that you have now.
Perfect. Thank you.
All right, thank you. Hey, Sue Suarez. Hello. All right. Y'all are, hi, how's it going? Okay. All right, you guys are up for jury trial. So come back at 1:30.
See you then.
Thank you. Jesus Zarate. Good morning. How's it going?
It's going well, thank you. How are
Awesome.
you?
Oh, I cannot complain. It's been a beautiful day. I got a chance to see the service animals.
Oh,
So I always tell people they're working. Does everyone give them money? They're working treats, you know? They do. They take very good care of them. All right, on this case, you all are scheduled for jury trial?
Yes, Judge.
You ready, counsel?
We're ready, Judge.
All right, I'll have you all back at 1:30.
Judge, one more thing, well, since the state's here,
Mhm.
regarding discovery, if they have anything new, like meetings with the complainant's mother,
Mhm.
I just asked that they provide those to me.
All right. All right, we'll go on the record. The court is calling 2025 CR 008-654 State versus Jesus Alanis Zarate. Could I have parties announced?
Defending for the state of Texas.
Good morning, Judge. Alfonso Cabañas for the defendant.
And are you Mr. Zarate?
yes,
All right, we have an interpreter here. If you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Carmen Tarragona Sáenz.
All right, so state off the record, the defense wanted access if it occurred of any meetings with the complainant and with the complainant's mother.
Right, Judge. So at the last court setting, I know that the state met with the complainant's mother and her husband in the back room. I wasn't given any of those meeting records, and I'm guessing since this is set for trial, I'm thinking that they probably met with the complainant and her mother. And if that's the case, I just asked them to provide me notes on those meetings.
Okay, so prior to the date that defense counsel referenced, we did interview both the child victim and the mother. Those notes have been provided to Mr. Cabañas. As far as the last setting, I did meet with them. In fact, there wasn't much discussed as far as any Brady evidence. There was mainly just them asking questions about court procedure that I answered for them. If Mr. Cabañas wants me to give him a disclosure about that, I can definitely type that up real quick right now and do it. They didn't have anything of substance related to the allegations.
All right,
Well, just to clarify, Judge, so there was not much Brady, which means there was a little Brady, or there
Okay,
was.
for clarification, there was an over.
okay. All right, so this is what I will do. If you all can step back, discuss things, and then if there's anything that needs to be placed on the record, just let me know.
Yes, Your Honor.
Okay, all right, thank you. Michael Timmons? All right, do we know, state where we are on the at-large case?
Judge, I talked to the state this morning. They notified me that there is an at-large case or case, I guess, still awaiting indictment. And that's all we
It
know.
is relatively new, Your Honor, and so it's being assigned to a prosecutor to review. Well, it is assigned to a prosecutor to review, but it has not yet been indicted. I don't think it's even on the schedule to be indicted yet.
Okay, so what I'm gonna do is I'm gonna give you all a 45-day reset. And then I'll entertain any motions if you have any motions
Yes, sir.
with regards to that case. Norma, I need a 45-day reset. June 11th, is
Yes,
that
Your Honor.
free? All right, thank you. Once you sign the reset form, you're excused. Thank you. Oh, and thank you for dressing appropriately for court.
Thank you, Judge.
You too, Mr. Cabanas, but you always do.
Morning, Your Honor.
Good morning.
How you doing today?
Oh, I'm doing great. How are you doing?
Good, good.
Okay. All right, you all are scheduled for trial today.
Yes, Your Honor. I filed that e-filed and conferred with the state regarding motion continuance. It should
Okay,
be-
I haven't received that.
Okay, there's a copy of it.
All right. So, Mr. Middlebrooks, are you aware of the motion for continuance that's been filed by your attorney?
Yes, ma'am.
Okay, we're gonna go on the record. Court is calling 2025 CR 008659. State versus Andre Middlebrooks. Could I have parties announced?
We're paying for the state, but also, Your Honor, we've got a second case as well.
Your Honor,
Thank you.
I don't have the printed copy of that.
All right, that's fine. And also 2025 CR 008659. So, defense, you only filed a motion for continuance in one case, is that correct, or both?
It is filed in the other case, Your Honor, although it was filed this morning.
All right. So, Mr. Middlebrooks,
Yes, ma'am.
I just have a question to ask you about this motion for continuance. I'm not going to ask you anything about your case. Could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Andre Meadowbrooks.
All right, Mr. Middlebrooks, your attorney has filed a motion for continuance. Did you have a chance to review that with him?
Yes, ma'am.
Do you have any objections to the motion?
No, ma'am.
All right. And state, do you have any objections?
No objection from the state, Your Honor.
All right, Ms. Ferguson, it will be granted. This needs to be set for jury trial in 6 weeks.
The trial seconds.
Norma, what case? I mean, what date? Did you say June? Mhm. You can put it for the following week. All righty.
We excuse Your Honor.
Yes.
Thank you, Your Honor. You have
You're
a good
welcome.
night.
Yeah, you too.
Yes, ma'am.
Christopher Finley. Hello. All right, where are we on discovery?
It's almost complete, Judge. We've received a lot of it.
Mhm.
The two same reports that were outstanding were just turned into the DA's office, so they're gonna get those uploaded. And we requested some missing text messages as well as a cell phone video.
All right, and when are the missing text messages?
I'm attempting to get those to her. Unfortunately, the victim is associated with that. It's not been responsive to us, so I'm hoping she'll answer the phone so I can get that from her to give to defense. I'm actively making the effort to do so.
All right, Ms. Ferguson, set this for mid-June for discovery, and at that time, state you'll need to be able to tender an offer.
Yes, Your Honor.
All right, June 16th?
Thank you,
Thank
Judge.
you.
May I be excused?
Yes. Paul Cantu? All right, so my question is, he has a hearing that's set. Are you on the CPS case or no?
No, I'm not. I'm not sure. You may want to ask him if he's even a party to the CPS case.
Okay.
Yes, I am.
All right, who's your attorney over there?
My attorney?
Yes.
Oh, it's, his name is Mark Baumbanger.
Oh, okay, I know Mark. And you know Mark.
Yes.
And do you know who your caseworker is?
I know her first name.
All right, so Attorney Wood, since I know you do work over there, can you get in touch with Mark and see who the child's attorney is over there?
Child's attorney is Sally Justice.
Ah, Sally Justice. All right, so do you have Sally Justice's number?
I do.
All right, if you can get in touch with them and let them know what the request is here, so that I can find out how is he doing in CPS court or not.
Okay, just by way of introduction, Mr. Cantu's been on deferred adjudication for 2 years. He's done everything very well. He even brought me a note to my office, which doesn't happen very often, saying how well he was doing. So if perchance Miss Justice says that she's not in favor, would the court entertain a motion to alter and amend?
Oh, yes, I'll still
community
consider it.
supervision?
I love information, and I think the more information, the better. So I know you're telling me you're doing great and that they're considering I guess, having visitation with you. So I'm just trying to figure out.
I already have visitation with my son.
Yeah.
That all they need is this condition change so that way he can come home.
Okay, so
I've-
that's
I've
what
done
I,
all my- I've done all my services through CPF.
so I appreciate you telling me that, but I'd like to get input from the child's attorney.
Sure.
And if they are at that stage in the case that he says they're at, I don't think Miss Justice will probably have any objection, but I just want Miss Justice input.
Do you want me to have him call you?
If you'll talk to Miss Ferguson, she can zoom in, or either we can do a conference call, whichever you all think is best.
Okay.
All right, and we'll get this done today.
Thanks, Judge.
All right, thank you. All right, the parties on Carlisle Klarner. Court is calling 2026 CR 003-113 State versus. How do you pronounce your name?
Carlisle,
And the last name?
Klarner.
Oh, okay, thank you. Carlisle Klarner, could I have parties announced?
Florida Espinoza for the state.
Jerry Valdez, Jr. for Mr. Coroner.
And are you Mr. Klarner?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, I have.
Mr. Klarner, did you review the application? Counsel, I'm sorry, I need you to sign. Mr. Klarner, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Klarner, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with possession of a controlled substance penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is from 180 days in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, he is, and he was.
Mr. Klarner, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his rights to jury trial. The court will find that the state is in compliance with discovery. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at an $800 fine probated. State recommends deferred adjudication. There's $65 restitution to the Bexar County Crime Lab for drug testing. Did you understand that to be your plea?
Yes, Your Honor.
State defense?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication before a term of 2 years, there be a TAP evaluation, 100 hours of community service restitution, the DOEP course, and regular random UAs. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Your Honor, please give it one in all attachments.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. Mr. Parn right now is unemployed, Your Honor, and it's because he's at Haven for Hope right now. He's in a drug rehabilitation program. It's gonna last approximately 3 months. He's been in there almost a month, Your Honor. So right now, while he's in there, they're not allowing him to work. So, because of the program, so
All
we're
right.
asking the court to take that into consideration right now.
What program are you in?
ITP,
Okay.
it's through Haven for Hope. It's on campus.
You said ITP?
Yes, ma'am.
Do you have any children?
No, ma'am.
All right, this is what the court is going to do. 2 years deferred adjudication, $800 fine to be probated, continued participation in the ITP program through Haven for Hope. You're going to need to sign a release so that probation can have information, you understand?
Yes, ma'am. Yes, ma'am.
Regular reporting by Zoom or in person, regular random UAs, proof of employment within 65 days, within 40 days of release from the program. $100 of community service restitution. With a deduction of 1 hour for every sober support meeting that is completed. Field visits 1 time per month for 6 months. There's $65 restitution to the Bexar County Crime Lab for drug testing. Probation, is there anything else?
Sorry.
100 hours.
Nothing else.
And of course, with the employment, no employment as a home healthcare provider or with minors. And no unsupervised contact with minors. Is there anything else that you need from the court to be successful?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. So just make sure that you stay on top of that program. Because if you start backsliding, then you look up, you're off track, okay?
Yes, ma'am. Yes, Your Honor.
And the other thing, get a handbook on the rules of the road when you ride a bicycle, right? A lot of people think you're allowed to ride bicycles on sidewalks, but you're not. That's one rule. The other rule they have is if you are walking, you are not allowed to walk in the street if a sidewalk is provided. So anytime you do that, an officer can stop you. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you so much.
You're welcome.
Thank you, Judge Rambutus.
Yes.
Thank you, Judge.
Who's next?
Daryl Payne, page 8 at the bottom.
Hi, welcome back. So how are things going with Mr. Payne? Oh, you're on this side. Okay.
Different in every court, Judge.
Okay.
Well, Judge, the last time we were here, I requested that Mr. Payne be screened to see if he qualifies for facts. I know that we got conflicting,
Yes.
reports on whether they were taking clients. I did confirm with his brother that he has well care, which is it's Medicaid. So I don't believe that evaluation has been done, Judge.
All right, so this is what we're gonna do. If you can confer with Miss Abrams and the coordinator, and let's see if we can get a Zoom. I know we tried to do it before, but life got in the way and there were issues outside of everyone's control.
Yes, sir.
Let's see if we can get together on a Zoom you all pick what date and we will have a Zoom to see what can be done.
Okay, and
I'll just confirm. All right, Mr. Payne, we're gonna see what we can do, okay? All right, thank you. And then just let me know what date.
Norma will know when you're available.
Yeah, and you'll speak with Ms. Abrams too.
Okay.
Hello,
Good morning.
good morning. How's everything going?
Pretty good. How about yourself?
I cannot complain.
That's great.
So, Judge, Ms. Aguero requested a transfer to Houston.
Mhm.
And I believe you had additional questions that you
Yes.
just wanted to ask her.
Yes, so in it, it says that you're going to be with your significant other
Sure.
and that the significant other is, they put in here, their main financial support. And so I'm trying to figure out who is there.
Myself and Layla, the 3-year-old.
All right. And is he the father of the 3-year-old?
No.
And so tell me, and I always ask these questions because part of my role is to protect the community.
I
right?
understand.
So what is your plan for being there? What's going to be the arrangement?
We actually just upgraded to a 2-bedroom apartment. I have the new address here as well. So that when Skylar, the 10-year-old, soon to be 11-year-old, comes to visit as well, they have their own room and more situated living arrangement. She is waitlisted, or Layla's waitlisted to go to school and get back into school. She was in Head Start here. It's just been a little bit more difficult to get her in the middle of the year now.
And I'm sorry, how old is she?
She's 3. She'll be 4 in October.
Okay.
And I work with her daily. We've bought books off of Amazon and things like that. In the meantime, I will be going to school, back to Oval School of Cosmetology.
So you'll be in school.
I'll be in school and he works and she'll be in school, but I'm getting her situated first.
All right, so she'll be in school, he'll be at work, you'll be in school. And then when she's released
Mhm.
from school, who's there to greet her?
Myself. It will be, the schedule is, I believe it's 8 or 9 to 5, Monday through Friday, the school schedule.
Okay. I always just want to hear about people's plans because I want you to be successful on probation. And sometimes I'll help people, as you can imagine, and even in practice, where people uproot their lives and then things fall apart. And then when things fall apart, children are sort of like, hey, my life has been uprooted.
Yes,
So
and
I just
and
want
I
to
know there's been a lot of that with everything in the past that's happened, and that's kind of why I wanna go to Houston, have a new beginning, somewhere fresh for the both of us. More stable lifestyle, with James, he's the superintendent for the hospitals there. Right now, he is currently going back and forth between night and day shift, which is why he couldn't be here, or else he would have been here as
So
well.
what does he do?
He's a superintendent for, he oversees the construction of the cancer hospitals in Houston.
Okay.
Mhm.
All right. And I'm sorry, what's the name of the person you're with?
James.
Okay. Okay. All right. Ms. Abrams? Yes, she can transfer.
Okay.
All righty. Good luck.
Thank you so much, Judge.
You're
Have a great
welcome.
day.
All right, you too. All right, who is here on Jay Taylor? And do you all have a date on Daryl Payne? Yeah, we'll do a Zoom meeting on May 4th. And then Norma, if you recall Mr. Payne for May 5th. All right, court is calling 2025 CR 008182 State versus Jay Taylor. Can I have parties announced?
Megan Galloway for the state.
Barry Wilson for defense.
And are you Mr. Taylor?
Yes, ma'am. How you doing?
Doing great. How are you doing?
Doing good.
All right. Did you review the motion to enter adjudication of guilt and revoke community supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision with your attorney? And did you understand it?
Yes, ma'am.
All right. Are you the same J. David Taylor who was placed on deferred adjudication in 2025 CR 008182 for the offense of robbery on August 18th, 2025 for a period of 4 years. Is that you?
Yes, Your Honor.
All right, state.
Violation of condition number 4 in Bear County, Texas, the defendant J. David Taylor did then and there fail to report supervision officer as directed for the months of November and December 2025 in violation of condition number 4.
How do you plead to that? True or not true?
This would be true.
And violation of condition number 4 in Bear County, Texas, the defendant J. David Taylor did then and there fail to report to the supervision officer as directed for the months of January, February, and March 2026 in violation of condition number 4.
How do you plead to that? True or not true?
This is true as well.
All right, did you understand by pleading true to violations 4 and 4, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in the prison and up to $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violations 4 and 4?
Yes.
Court will find 4 and 4 true. Is there a proposed agreement?
There is not, Your Honor. The state is asking that you grant the state's motion and enter an adjudication of guilt against the defendant, revoke his community supervision and sentence to 6 years.
All right, and defense, what are you requesting?
We're requesting that the court follow the probation's recommendation, which is to continue him with bi-weekly reporting. It also references a mental health evaluation that was scheduled for May the 4th of 2026. Now, in conferring with my client, he has said that he doesn't see the need for that mental evaluation. As mentioned in the recommendation from probation, it says that when he was reporting, it had mentioned some mental health issues, and that's why that was scheduled. At this current time, he is saying that he has, let me back up. Bottom line is he's saying when he was in jail for about 4.5 months prior to this offense, prior to being placed on deferred adjudication. When he was released, he had lost everything, his apartment. And one of the main things that happened was that he had all of his identifying documents were gone.
So here's
and he can speak.
the big question is, why didn't he report? He's been missing since 2025. So that's the number one question.
And what I would say, Your Honor, is that I've advised him of the issues involved with you testifying at this proceeding, but would you like to further expound for the court why it is you were not reporting? Remember, this is what we've been talking about the whole time, that's what the court's going to want to know.
Yes.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
J. David Taylor.
All right, why were you not reporting?
Basically, when I got out of jail, I basically lost everything. I went through an eviction. I lost the car, my phone. They basically just threw all my stuff away, my documents, school transcripts, everything I had worked for. And then I basically missed the first probation, like by 3 or 4 days. So I figured they had a warrant out. So I just wanted to kind of show up to probation with a payment because I had went the first 2 or 3 months and they were requesting like $80.
All right, everyone whisper. We're on the record. I cannot hear. All right, you may continue.
I wanted to at least go to probation with a payment. It was kind of unusual not having employment, but due to not having my documents, I wasn't able to secure a job. So I know it doesn't allow a lack of accountability, but now that I do have some of my documents retrieved, like my birth certificate, I got my social, and I'm working with KRL and Corazon Ministries, and hopefully Haven for Hope will accept me. So I'll have like a place to stay. It shouldn't be a problem in the future.
All right.
And so, Your Honor, we would ask the court to consider continuing him. He also has job prospects. He actually has a job, they're saying, with factory. And so he had issues, but we think that if the court were to continue him, that it would not be an issue moving forward, Judge. If the court is not inclined to continue him, we would ask the court to consider the minimum.
Well, no. Any questions?
I do. Okay, and so at the time that you were placed on probation, the address that you provided was that you were living at 1 Haven for Hope Way. Is that where you were living at the time?
I was at Haven for Hope. That was the last address, but this would be like 8760 Fairhaven. That
Okay.
that was the last address for us.
So hold on, so before you went into jail, you were living at Haven for Hope,
No, I was living at Fairhaven.
at Fairhaven, and then when you were released from jail, where did you go? To Haven for Hope? or
Well,
to
I was
Fairhaven?
evicted, or I didn't have that apartment anymore on Fairhaven, so I went to Haven for Hope, and they said I needed a referral to get back in since the last time I wasn't there for more than 30 days.
Okay. And then you reported to probation that you were unemployed.
Right.
Okay, so why did you report that if you had a job?
I didn't have a job at the time that I was
Prior.
out of jail. I was in there for 4.5 months, so I didn't have employment at the time or my documents or anything.
So are you saying prior to being in custody at the jail, you had a job?
I
Or
would
no?
say I was working at the time, right? I worked down on Grayson.
Oh, okay, okay, and then you're saying you lost that job as a
Right,
result
yeah,
of being
and being
custody.
in jail for 4 months, they said I was like, no foul, no show, so they terminated me.
And then I guess just as a result of you losing your identifying documents and stuff, that's not something that you have to show to probation to report, correct?
Right.
Right, so how did that have an effect on you not?
I would
reporting?
say, the first 2 months that showed up, they were requesting $80. I was, always used to, providing and paying rent, so. Not having, a job and then trying to reapply was difficult due to the fact that I didn't have a social birth certificate or anything. They basically just threw all of my stuff away.
Okay. And then I guess you also said that you were scared because you were a couple of days late and you didn't.
Right,
you
the
didn't
last
go to jail.
probation date, I think around December, whenever I guess prior call to verify the date, I still kind of missed the date by like 3 days or so, so I figured they had a warrant. And I just wanted to kind of gather my documents, et cetera, and at least bring the payment.
Okay,
But
all right, thank you. No further questions.
All right. Court will hear argument.
Judge, we're just asking for you to grant the state's motion and submit him to 6 years in prison.
Your Honor, we would ask the court to consider probation's recommendation. They know this client. They know his demeanor. They know what he has been doing. One thing that was not mentioned, he was homeless at the time, living under the bridge. Is that correct? Right. So there were some significant transportation issues. But we would ask the court to consider probation's recommendation of having him to report bi-weekly. He understands that if he were to violate again, that he is still facing a full range of punishment. If the court is not inclined to continue him on his probation, we would ask the court to consider the minimum here, which will be 2 years based on the actual offense, which he has yet to be adjudicated for, but that he did plead guilty to, or no contest.
All right, I never understand how someone, if you didn't report for all this time, I don't understand how, okay, we're gonna make them report double means, helps with anything. I don't see that as being rehabilitation. All right, this is what the court is gonna do. The court is gonna grant the state's motion, revoke, find you guilty. There's to be no contact with Erica Aguilar, no contact with the Dollar General. The court will request the therapeutic community, and the court will sentence you to 4 years in the prison, give you credit for any time served. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney, and I'll retain jurisdiction. All right, thank you. Zachary Garcia. Are you all proceeding on the motion to revoke?
The recommendation was to extend 1 year, alter and amend the conditions to an inpatient treatment.
All right, I don't know if I'm going to do that. So are y'all proceeding on the MTR?
Yes, we're prepared to plead true to the one violation.
All right, the court is calling 2023 CR 6331B, State versus Zachary Garcia. Can I have parties announced for the record
$100,008.
for the defense?
Mick Aguilar on behalf of Zachary Xavier Garcia.
And are you Mr. Garcia?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Zachary Xavier Garcia who's placed on deferred adjudication in 2023 CR 6331B for the offense of assault on a security officer on November 6, 2023 for a period of 3 years? Is that you?
Yes, ma'am.
All right, you may proceed, state.
On or about the 23rd day of March, 2026, in Bexar County, Texas, the defendant Zachary Xavier Garcia did then and there fail to comply with treatment alternative to incarceration recommendations through Bexar County CSCD in violation of condition number 28.
May you plead to that true or not true?
True.
All right. By pleading true to violation of condition number 28, did you understand the court could revoke your probation, your deferred adjudication, find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 28?
Yes, ma'am.
Court will find violation of condition number 28 true. Is there a proposed agreement?
Yes, Your Honor, proposed agreement is to deny the motion to revoke, extend the probationer for 1 year and include in his conditions the ISF2 program, followed by aftercare with the intermediate sanctions program unit.
All right. So here's my question. So it's saying that he failed to comply with the TAP recommendations, and what were those recommendations?
The outpatient treatment.
And what do they mean by he failed to comply? He just said, I'm not doing it?
Oh, no, ma'am. I worked almost 65 hours a week, so it was hard to do that and go to the classes.
So probation,
Initially, this hard IOP in November, he's showing minimal effort and exceptions, having a non-compliant attitude and limited commitment to recovery. We did a revised TAP, and that revised TAP, so that was that. We did a revised TAP, the revised TAP indicated for him to for local ISF. In addition to getting some outpatient treatment, the TAP recommendation included monthly UA and documented sober support.
all right. So you're telling me that you couldn't do this because you had work and other things, and now they're still sending you to inpatient.
All right.
I mean, are they sending him to local ISF and that's inpatient?
That is inpatient, Judge. He just wants you to know he's 27 years old. He, okay, I'm sorry, 28. He is responsible for 5 children. And he put work first, working a mess of hours in effort to support the kids and family. He now realizes that supervision, probation, especially in our court, is very serious, that he should have been complying. He understands now that there's a possibility of, number one, getting revoked, number two, doing an inpatient treatment that'll take him for the next 5 or 6 months to complete. Inpatient, away from those 5 kids.
Right. And I'm sorry, state, you may be excused. All right, probation, what are you recommending? Do you think this is that he'll be able to complete this?
Judge, the substance that he was tested positive for was marijuana, and that there was some failure to submit. So that's been consistent throughout his entire probation term. He says that he has completed the anger management class, but we don't have anything on file to report that he did complete his parenting class, which gave him the first service hours. I don't show that there's been any payment date in his account.
You want to address that?
Oh,
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, ma'am.
All right, you can lower your hand, state your name for the record.
Zachary Garcia.
Why are you not doing well on probation?
I work long hours to provide a roof over my kid's head, my wife. I've got to pay rent, car, light, electricity, and just, I have all these payments, and I also pay child support. So I have to make I have to get enough hours to pay child support and have money for my family for bills and food on the table and clothes on my kids' back. And it's not that I didn't want to comply, it's just that doing everything for my family is what I feel like I should do. Like I'm not a bad person. I just try to work as much hours as I can just to provide what is needed for my kids for school, at home, and just to have a roof over their head. And I just try to be a good father to my kids. Children, yes.
Which he is reporting. He has reported, he has taken the UAs, he has missed a couple, and he's had a couple come back positive for marijuana.
What is with this marijuana?
I was going to get my license to get it because I have real bad anxiety and I get overwhelmed fast. So I guess, I mean, that's not an excuse, but like
No, it is not.
It helps like with
When's the last time you used?
Since November, going into November now. And I was incarcerated in January for child support, and I've been clean since. And I was given another chance, and I surely I could prove myself.
All right. Ms. Abrams, this is what I'm going to do. Deny the motion, alternate amend conditions to include intensive outpatient treatment, UA hotline for 60 days with testing at least once per week. If any classes for the intensive outpatient treatment is missed, if any UAs are missed on the hotlines, then a motion to revoke will be filed. Do you understand?
Yes, ma'am.
Anything else, Ms. Abrams? All right, thank you.
Thank you, Judge.
Ledesma? Do y'all have the motion?
I do not, Judge. I actually didn't realize that it was even set for today.
Could I have a file on this case, please?
That doesn't, Isaiah?
All right, this is set for this is set for a motion to revoke. Are you all ready to proceed?
No, Judge.
All right, Ms. Ferguson, recall this in 10 days for a contested hearing. All right, see y'all back on May 7th for a contested.
Do we need to set for a different day on the motion to withdraw? Sorry, Judge, just let me give you a heads up.
Yes.
So my client was arrested in Guadalupe County.
Mhm.
And that was about a year ago-ish. He had hired me on all cases, including this one.
Mhm.
They then terminated my services almost a year ago at this point. Back then, we filed a motion to withdraw. However, because he was still in custody in Guadalupe County, couldn't have a hearing on
Can
it.
I see the motion to withdraw? He said he filed one. All right, so your counsel actually filed a motion to withdraw July 2025. Are you aware of that?
Yes, ma'am.
And it's my understanding is that you all released him from services. Is that correct?
Yes, ma'am.
All right, we're going to go on the record. Court is calling 2022 CR 6907B State versus Isaiah Ledesma for the defense.
John Pettis.
And are you Mr. Ledesma? And do you have any objections to defense counsel withdrawing?
No,
All right, then that will be granted. You're excused.
thank you, Judge.
You're welcome. Who's the attorney for Victoria Mora?
I am, Your Honor.
All right,
Good morning.
good morning.
My client failed to appear. I have not been in contact with her.
Is she on a commercial bond?
I'm not exactly sure what type of bond she's on, but I was planning on checking that out, see if I can call the bonds. And
Oh, well, you want to see if you can call the bondsman if she's on a commercial bond?
sure, let me check now.
All right, and then just come back up and I'll take care of it. It's a PR bond?
Yeah.
All right, if you all can make an announcement for Victoria Mora. All right, court is calling 2026 CR 0035599 State versus Victoria Mora. Could I have parties announce?
Alexander Kraus for the defense.
All right, this hearing is scheduled at 9 a.m. It is now 11:06 a.m. The defendant has not made an appearance. Deputy, did you make an announcement?
Yes, Your Honor, I did need a
Defense, have you had any contact?
No, Your Honor.
State?
You would request a bond forfeiture, Your Honor.
All right, the court will issue a judge's warrant and remand your client without bond.
Thank you, Judge.
Thank you.
Morning, Your Honor.
Good morning.
How are you?
Oh, I'm doing great. How are you doing?
I'm good. I'm good. Getting older, like everybody else.
All right, where are we on this case?
What?
Okay,
okay,
so
go ahead.
last time that we were here, the autopsy report and the discoveries in the medical examiner's office was missing. So that has been turned over. It was uploaded to our e-discovery system, which is Axon. Ms. Claudia was telling me that she's having trouble accessing it. So I did provide her copies of that and
Right now, today.
and then I did email our IT department, see if we can get her access to the online system as well.
All right, Ms. Ferguson, recall this for a final discovery at the end of June.
Thank you, Your Honor. In the meantime, the state and I will talk.
Okay,
Yeah, thank you, Your Honor.
all right, all right, June 29th. Thank you. If your attorney wants you brought back sooner, we'll be informed.
I'll do it, yeah.
All right, thank you.
Thank you.
Thank you. I'll call you.
All right, Mr. Robinson. Court is calling 2025 CR 012572-02 State versus Carl Robinson. Could I have parties announced for the record?
State.
Michael DeLeon for Mr. Carl Robinson.
And are you Mr. Robinson?
I am.
All right, so I did find you guilty. And I took an extra day just to consider whether or not I would grant your application. And I will tell you, there's a lot of things for a judge to weigh when they're considering whether or not to grant someone community supervision. Like sometimes people will say, well, you gave that person deferred. Why can't I have deferred? It's the same thing. But I try to stress to people that each case is individual, right? And there are certain facts in certain cases. Like, for example, I know part of the argument is like, well, the co-defendant got deferred adjudication. And I understand that potentially this never would have happened if she hadn't agreed to meet up with somebody, pretend that she's going to be intimate with them, and then they're being set up to be robbed. And I know that person doesn't come with clean hands either, meeting some stranger at a hotel room. But in your case, the facts are that you went there and you went there with the intention to rob. This isn't something, according to the stipulations that I've read, this isn't something where you just happen to be there, you're upset that your girlfriend is agreeing to be intimate with this person. This was all set up for a robbery. And then in the stipulations, the guy says that you were trying to test whether or not his gold chain was actually gold or test the weight of it. So those are problems that I have. And I do realize that you're young. I do realize that the state proceeding on this case as a robbery. So this is what the court is going to do. The court, as previously stated, is finding you guilty. The court will sentence you to 4 years in the prison. The court will retain jurisdiction. Court will give you credit for any time served. And the court will request the therapeutic community. Is there anything else with regards to sentencing?
Nothing, Your Honor.
All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so I've retained jurisdiction. Your attorney knows what that means, but if you're coming back to me, you're gonna have to show me something and he'll inform you what I mean by that. All right, thank you.
Thank you, Judge.
All right, the court is calling 2024 CR 3533 Sate versus Alex Miosek. Could I have parties announced for the record? Hello. Are you Mr. Miosek? All right, did you review the document entitled Motion to Enter Adjudication of Guilt with your attorney? Did you understand it? Are you the same Alex Miosek who was placed on deferred adjudication in 2024 CR 3533 for the offense of assault causing bodily injury to a family member on November 14, 2024 for a period of 2 years? Is that you? State?
Yes, Judge, we're proceeding on 2 violations. Violation number 1, on or about the 8th day of February, 2026, in Guadalupe, Texas, the defendant, Alex Miosek, committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
Not true.
And proceeding to violation number 20, on or about the 23rd day of January, 2026, in Bexar County, Texas, the defendant, Alex Miosek, did then and there failed to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 20.
How do you plead to that? True or not true?
Not true.
All right, state. You may
Yeah.
proceed. Call your witnesses.
Yes, Judge. The state calls Marco Vergara.
All right.
Sorry, before we begin, I am not set up with my laptop and I don't know if we're expecting to do it at the bench, but I would prefer to sit at the council table if I could.
Okay, well, they have other things at the council table. I mean, you're more than welcome to sit your laptop up here. Is there room for it up there?
I think they said I could sit there, so if that's okay with the court.
All right, fine. All right, state, you may proceed. Who's your witness?
Thank you, Judge. Mr. Vergara.
All right, could you unmute, raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Any objections to the witness appearing by Zoom, state, defense?
No, Your Honor.
All right, state, you may proceed.
Thank you, Judge. Mr. Vergara, can you please say your name for the record?
My name is Marco Vergara.
Thank you. And what's your current occupation?
I'm a community supervision officer for Bexar County.
And how long have you been employed as a CSO?
I've been employed as a CSO since about late October 2025.
And what agency do you work for?
Can you repeat the question?
What agency do you work
I work for Bexar County Adult Probation.
for? Thank you. And you just briefly describe your duties as a CSO?
My duties as a CSO, including supervising probationers during their term of deferred education or regular probation, ensuring that they're submitting to UAs, filing paperwork with the court, making sure that they're compliant with the conditions such as BIP or no contact orders, and then going over their fees and seeing them every month as well.
Okay, thank you. And Mr. Vergara, are you familiar with the defendant in this case, Mr. Alex Miosek?
Yes, ma'am.
And were you assigned as a supervision officer for this defendant?
Yes, ma'am. I took over supervision for Mr. Miosek in about early November 2025.
Okay, and before that, was it another officer, CSO, supervising him?
Yes, ma'am.
Okay, and have you reviewed the defendant's file?
Yes, ma'am.
Okay. And was the defendant placed on community supervision by this court?
Yes, ma'am. He's placed on deferred adjudication on November 14th, 2024 for 2 years.
2024. And for what offense was he placed on probation for?
He's placed on a deferred adjudication for assault.
And are you familiar with the specific conditions imposed on this defendant?
Yes, ma'am. I'm aware of his conditions.
And are those conditions clearly explained to the probationer?
Yes, ma'am. When individuals granted probation, they see intake and then they're read to them their conditions. And then during their initial visit with their assigned CSO, the conditions are reviewed again as well. And then we also review conditions during their office visits that are assigned by the court.
Okay, you previously stated that there was another CSO previously assigned to this officer. So when you were assigned to these officers, do you go over the conditions with the probationer?
I go over their conditions assigned by the court at every visit. So the no harmful injurious contact orders or classes, but the full conditions, from my understanding, are reviewed by the initial CSO.
Okay. And is the defendant's responsibility to comply with those conditions?
Yes, ma'am.
Okay. Okay, can you please tell the court what conditions did the defendant violated on the violation report submitted?
Yes, ma'am. On roughly on February 12th, 2026, I was contacted by Shirts Police Department informing me of a new assault charge, and that the victim in the new case was wanting to press charges. And so we went ahead and did the violation report. And then upon reviewing his file again, I noticed that he had failed to submit to UA testing in January. After the January office visit, he was directed to submit by, I believe, that following Friday on January 23rd, 2026, and we never received a UA submission. So a violation report and a motion to revoke was filed in the court.
Okay, thank you. So are those the only violations that he committed?
Yes, ma'am.
Okay, no, pass the witness.
All right, defense?
Mr. Regatta, can you hear me?
Yes, sir. I can hear you.
All right, good morning. How are you?
I'm good. Yourself?
I'm doing well. I recognize your face. I did not know that you had gone to work for the probation department. You used to work in the courthouse, right?
Yes, sir. I used to be a court clerk.
Yes, okay. It's good to see you again. I do have a few questions for you. You told Judge Boyd that Alex had been placed on deferred adjudication in November of 2024. Is that correct?
Yes, sir.
Were there any previous MTRs filed other than the one that we're currently here for today?
No, sir. Not to my knowledge. I haven't seen any previous MTRs or VRs filed in the past.
Okay. And with regard to the violations, you had mentioned that you had received information or a call that there was an assault allegation out of a different county. Is that correct?
Yes, sir.
Now, to be fair, you do not know or have any personal knowledge about any assault allegations regarding Mr. Mayosek, correct?
Nothing other than what was reported to me by Shirts Police Department along with officer report. I know nothing else, sir.
But per adult probation policy, I assume if you receive that information, are you obligated to go ahead and request that an MTR be filed or start preparing the paperwork for an MTR?
From my understanding, yes, sir. Once we get a notification from another agency or county, and then we get the offense report, we file the VR to MTR.
All right. And in addition to that, I guess when you have an allegation like that, you start to go back and look through chronos and review the history of this particular individual to find out, hey, is there anything else we can add in here? Is that not a standard practice?
Yes, sir. We just review, make sure that, and see, verify if any other conditions have been previously violated, add them onto the MTR. But other than the failing to submit to the UA, that was the only other violation that Mr. Mayosek had done.
Okay, and outside of the allegation that was made by the Guadalupe County authorities. If you had to give Alex a grade on his probation performance up to that point, what would you give him?
Up to the point of the violation from Guadalupe County, Mr. Miosek had been compliant with probation, and we hadn't had any issues with him reporting or anything, and he had maintained communication.
Okay, Mr. Vergara, I appreciate your time today. That's all the questions I have, Judge.
Any other questions?
Yeah, just to, Your Honor. Officer Vergara,
Yes, ma'am.
so for violation, condition number 20th, that condition, was it in Bear County?
Yes, ma'am. That condition was in Bear County. You're talking about the failure to submit, correct?
Yes. Okay.
Yes, ma'am.
Thank you. And I know it might be a little difficult because you're on Zoom, but do you see the defendant in this courtroom?
Yes, ma'am. I see him on the second table to the right, wearing the polo.
Okay. And can you just briefly describe a clothing, color of clothing?
He's wearing a what looks like a beige colored polo,
Okay.
and he has a
Thank you. Let the
watch.
court, I'm sorry, let the court reflect that the officer has recognized the defendant. No further questions, Your Honor.
All right, is this witness excused?
Yes,
Yes, State.
All right, you may be excused. Thank you. State, call your next witness.
Yes, Judge. The state calls Mr. Ernest Acevedo.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
I am Officer Ernest Acevedo.
Any objection to this witness appearing by Zoom? State defense?
Not gonna say.
No.
All right, you may proceed.
Thank you, Judge. Mr. Acevedo, can you please state your name for the record?
My name is Ernest Acevedo.
And what's your current occupation?
I'm a supervision officer with Bear County Probation.
And how long have you been a supervision officer?
It's a little over 10 years.
Okay. And Mr. Acevedo, are you familiar with the defendant, in this case, Mr. Alice Music?
Yes,
And were you initially assigned as a supervision officer for this defendant?
yes.
When was that?
When he was granted in November 2024,
Okay.
up until September 2025 was the last time I saw him.
Okay. And for how long was he placed on probation for?
2 years.
Okay. And did you go over the conditions with the defendant?
Yes,
And did he acknowledge that he has to comply with those conditions imposed by the court?
yes,
Did he sign a form stating that he understood those conditions?
yes. He signed those conditions at intake.
And what's the date on that he signed those conditions?
He signed those November 15th, 2024.
And on what date did yourself went over the conditions with him?
I met with him for the first time December 17th, 2024, which is when I reviewed the conditions with him.
And does that include condition number 1?
Yes.
And can you please just read condition number 1?
Neither commit nor be convicted of any new offenses against the laws of the state of Texas or any other state of the United States of America.
Okay. And to your knowledge, does he have a report, violation report submitted?
To my knowledge, yes, the report was submitted.
And for what offense?
What are the allegations on the MTR you're asking?
Yes, sir.
Number 1 and 20.
Can you please go over violation number 1?
Oh shit, I don't have the. On or about the 8th day of February 2026 in Guadalupe County, the defendant Alex Milchek committed the offense of assault.
Okay, thank you. I pass the witness.
Defense?
Mr. Acevedo, good morning.
Hi.
How much time did you supervise Alex? You know?
I supervised him from December 2024 to last time I saw him was in September. I'm sorry, September 2024 to September 2025.
And then Mr. Vergara assumed responsibility for him?
Yes, sir.
Okay. So almost a year that you were working with him?
Right.
In that year, did you ever submit any violation reports to the court?
No, sir.
To your knowledge, did Alex ever give you any issues or any problems?
No, sir.
Would you consider or describe Alex as a good or model probationer?
He was doing well when I was seeing him.
All right, I appreciate your time. That's all the questions I have.
All right, any
Thank
further
you.
questions?
Not from the state, Your Honor.
All right, is this witness excused?
Yes.
Yes, Judge.
All right, you may be excused.
Thank you, Judge.
Thank you. Call your next witness.
Oh, yes, the state calls Miss Olivia Weiss.
Good morning. If you raise your right hand for me, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. Please keep your voice up so that everyone can hear.
Olivia Weiss.
All right, you may proceed.
Thank you, Judge. Good afternoon, Miss Weiss. How are you doing today? Is it okay if I call you Olivia?
Yeah.
Olivia, where do you currently live?
In Shirts.
Okay. And do you know the defendant?
Yes.
What's his name?
Alex Music.
Okay. And how do you know him?
He used to be my partner and he is my daughter's father.
Okay.
Judge, may I interrupt?
Yes.
Is there any reason she's not in the witness stand?
Do you want her in the
I
witness
would
stand?
prefer it. It's very
All right, if you could take the witness stand and please keep your voice up.
Thanks.
All right, make sure you keep your voice up so everyone can hear. All right, state, you may proceed.
Thank you, Judge. Okay, I believe the last question I asked you was, how do you know the defendant?
He used to be my partner and he is my daughter's father.
Okay, so are you currently or not currently in a relationship with him?
No, there's no relationship.
When was the last time you talked to him?
Beginning maybe like the second week of February.
Of this year?
Yes.
Okay. And Olivia, did you know the defendant on February 8th, 2026?
Yes, ma'am.
And were you in a relationship with the defendant at that time?
Yes, ma'am.
Okay. Were you living together?
Yes, ma'am.
Okay. And can you explain to the court what were you doing on February 8th, 2026?
We were at a birthday party for one of his coworkers. We were at her apartment celebrating, then we went to a bar, and then we went home.
Okay. And what happened when you got home?
We got into an altercation after we started to settle in for bed. And he punched me in my face and he punched me in my nose.
Okay. So, and let me just go back. You mentioned earlier that you all went to a bar, right? Were you all drinking?
Yes, ma'am.
And what were you drinking?
I had some seltzers, White Claws. And I think like some of a mixed drink, but I didn't even finish it.
Okay.
That was all.
What about the defendant?
With liquor mixed drinks and White Claws as well.
Okay. And at what time did you all leave the bar?
We didn't end up probably almost 3. So we got home, or I'm sorry, maybe more like about 2:30, 45-ish, because we didn't get home until a little bit after 3 o'clock. We only lived like 20 minutes from the bar.
Okay, so that was on Saturday, right? When you all went to the bar?
Yes, it was
And
technically
then
Saturday
late,
night falling into the Sunday. morning,
okay.
yes.
So you got home around 3 AM. Okay. And what was the altercation about?
Sorry, I just feel like, a little explicit. I was starting to fall asleep and I didn't want to have sex.
Okay. And what happened after you informed him that you did not want to have sex?
Said something pretty explicit and disrespectful.
Okay.
So of course I was upset by that as well. And then it started to rise into the argument that it became.
Okay. So you never had sexual contact with him?
Not that night, no.
Okay. And what happened next, Ms. Olivia? Take your time. Okay.
When he punched me on my right cheek, I was turning to get up out of bed. He grabbed the back of my shirt and it ripped down its side. Now, of course, I have no shirt on. And I tossed my shirt, he tore my shirt off of me. He's now calling me names because of my shirt being ripped off of me. I'm upset. So you ripped my shirt, you punched me in my face, and then he punches me in my face. And there's blood all over my bedroom, all over me, all over the shirt that was torn.
How many times did he punch you?
That night, twice.
And where exactly did he punch you?
On my right cheek.
On both times?
This was once, and then my nose as well.
And what did you do after he hit you?
I said you broke my nose.
Okay.
What you did to me. He said, you did that to yourself, quit playing victim. And that repeated back and forth, and then I locked myself in the bathroom.
And what did you feel when he punched you?
Physically, or?
Yes, ma'am.
Extreme pain. Felt like my face exploded. My gums here were all bruised as well, so my mouth was hurting. All of my face here was hurting. In between my eyes was hurting. I could barely even gently rub near my eyebrows without it hurting. My whole face hurt.
Okay. And you said, you mentioned earlier that you went to the restroom.
Yes.
What was he doing when you went to the restroom?
He left.
He left the house?
Yep.
Okay. Did he come back?
No.
Okay. So when you were at the restroom, what did you do?
I was begging for him to bring me ice because my face hurt so bad. And I just sat on the floor crying, looking at my face.
Okay. Okay. So you mentioned earlier that he left. So when you were in the restroom, he was still there?
Momentarily, and then he ended up leaving.
Okay.
He thought me asking for help was from him, was me on the phone with somebody else. Which I was not.
How long were you in the restroom for?
And I don't know, maybe 10 minutes.
And what did you do when you were in the restroom?
I took pictures of my face and I just sat there and cried.
Was anyone else present at the home when this happened?
Not at the time of it happening, no. My dad later arrived to take me to the hospital where I got a CT scan.
Okay. Your Honor, may I approach the witness?
Yes.
Showing you what has been pre-marked as state exhibit number 1. Do you recognize this, Miss Olivia?
Yes, ma'am.
And what is this?
It's a picture of my face covered in blood from my nose.
Okay. And when exactly did you take the picture?
Minutes after we punched me.
And this photo is fairly accurately depict what happened to you that night.
Yes, ma'am.
Tendering defense for any objections.
No objections, Judge.
All right, and you're offering to admit what's the number?
State exhibit number 1.
All right, state's exhibit number 1 is admitted without objection.
Yes. Okay, so what did you do after you were in the restroom? You mentioned that you called your dad, and what happened next?
I had the CT scan done at Northeast Methodist Hospital. They also noted that my right cheek was swollen and bruised, my gums were bruised, and a scratch on my upper lip, and that my left nasal bone was fractured.
Okay, and at what time did you arrive to the hospital that night?
5 a.m. I didn't leave till like the sun was up by the time that we had left.
Okay, and were there any cameras recording at your house or anything?
The baby monitor that we do have was not recording because I did not have an SD card in that camera at that in my bed.
Okay. Okay, did at any point did you call the officers, police officers?
While I was at the hospital, I report with the shirts police department. Yes.
And did the officers get there?
Yes, ma'am.
And was it the police report made on the hospital?
Yes, ma'am.
Okay. And did you return to your house after the incident?
Not until Monday. After the hospital, I went to my parents' house.
After a hospital, okay. Did you have any contact with the defendant afterwards?
Briefly.
What about?
Just him coming home. I told him it wasn't a good idea because I filed a police report and a protective order. And I was worried of his reaction or retaliation. I didn't want him to know that I did that yet. So I was waiting until that went into effect.
Okay.
So it was just honestly kind of stalling. He wanted to try to come grab his things or see our daughter, but I did not feel safe for that.
Okay.
So I said I didn't feel good. It wasn't a good idea. Etc.
Did he respect your decision?
To an extent. After a while, he started to be. He started to show more aggravation that I would not answer the phone, or that I was acting different, or let him over. That I changed the locks, so that made me feel a little bit better.
And when did you end the relationship with him?
The second he broke my nose.
Okay. Okay. And where did this incident happen?
At my home in Shirts.
Okay. What county is that?
Guadalupe County.
Guadalupe County. Okay. Do you currently live there still?
I am.
Okay. And Miss Olivia, how are you feeling emotionally after all this happened?
Terrible. It's my daughter's father. No one wants to be put in this position by their partner, but no one also wants to see their partner in that position either. But I have to stick up for myself, for my daughter. So I've been upset, but I feel really confident that I am hopefully displaying what my daughter should and should not tolerate one day.
Thank you for that, Ms. Weiss. I pass the witness.
Defense.
Ms. Wise, good morning. You and I have actually never met or had an opportunity to discuss any of the events of that February morning, correct?
No, we're not met this week.
Okay. Now, you have talked to a lot of different people about the events of that day, correct?
When you say a lot of different people,
Well, you talked to a police officer on a phone call. Do you remember that?
yes.
Did
Well,
you?
I spoke, when I made my report, I was at the hospital.
Right. But before the police officer that you spoke to at the hospital came and saw you, do you recall having a phone conversation with a police officer who then came and saw you?
I thought I was just speaking with dispatch, so I was making a report. The person I spoke with was a woman, and then the officer showed up as a male.
Okay. All right. At some point though, while you were in the hospital, you do recall a police officer coming to talk to you,
Yes,
and your dad was there,
yes,
and you and your dad had a conversation with this police officer about the events and details of the last 3 to 5 hours. Does that sound about right?
yes,
You also spoke to your father, correct?
yes.
And I don't know who else you may have talked to, but you've spoken to at least 3 or 4 or maybe 5 different representatives from the district attorney's office. Is that correct?
Yes.
You've also spoken to a prosecutor that works in Guadalupe County. Her name is Brianna Vela.
Yes, sir.
All right. And so the reason I'm asking you about this is it seems like you have a pretty vivid recollection of the events and the details of that night, and you kind of regurgitated the story to about 10 different people. Does that sound fair?
Yes, sir.
One thing that I found interesting was in your testimony, you said you were talking about the cameras, and you said, unfortunately, that there was no recording of the incident because there wasn't an SD card in that tube. Correct?
Yes, sir.
Okay. Is that is that a detail or something you told these prosecutors?
Yes, sir.
Are you sure?
I'm positive.
Okay.
That SD card has not had, that camera has not had an SD card in it since January 1st because it broke when I was trying to keep the camera.
So you're certain that when you sat down with Miss Jones and whoever else, that the SD card came up because the recordings came up and you told them there would have been a recording, but there was no SD card.
If we are mentioning on possibly hearing audio, because we have multiple cameras since he broke the other one that I was able to use too, an SD card would not fit into the broken camera. I could not have an SD card in there.
Okay. But you do recall telling all the prosecutors and interns and whoever else that was there, the only reason there's not a recording is because there wasn't an SD card.
Yes, I'm sorry, I'm confused by the question.
Well,
I said there's a possibility I was able to receive the video and then I realized there's no SD card. It overlaps. If there's nothing in there, I can't forward the video.
do you recall telling the prosecutors that you met with that you had an audio recording of the incident?
I said there was a possibility. And I realized that possibility was not possible. I was not able to receive that.
Okay, Ms. Wise, let's kind of circle back to all the people that you talked to. Now, would you agree with me? Here we are in court. Alex's livelihood, freedom, it's on the line, right? You understand that?
Yes, sir.
And the information that you're providing is going to be critical for the court to consider in deciding what to believe and what to do. You understand that as well.
Yes, sir.
So I'm just wondering, is there anything about that night that you just completely left out of your narrative and never told anybody?
No, nothing that would make any difference. He broke my nose.
Okay,
There's no changing.
okay.
I'm not leaving out or lying.
Okay, you're kind of answering a different question, but I'm asking you, are there any details about that night that for some reason you just have chose not to tell anybody?
Anything other than explicit words that would just be inappropriate to repeat, no. Words by him that I would not feel comfortable repeating in a public courtroom.
All right, so then let me ask you this question. After the incident, as you described it here today, Alex left the apartment, correct?
Yes, sir.
Okay, and was gone, right? He did not come back, did he?
No,
Do you know where he went?
he went to my mom's house.
Okay, how do you know that?
I tried to get my house key from him and I have his location.
Okay, and that's kind of what I'm getting at. You never told anybody, that once Alex left the house, you, and you were in an inebriated state. Can we agree on that?
I was going to drive.
Okay, but do you remember telling the prosecutors and the police that you were drunk? You had a lot to drink?
I didn't say that I had a lot to drink. I had been drinking that night.
Okay, we can leave it at that. But the second Alex left the house, the first thing you did was get in your car and go pursue Alex.
That was not the first thing that I did. I sat on my floor for about 10-15 minutes, took a picture, cried, realized he had left. The reason why I had not mentioned it is because I didn't think it was relevant, but I tried to get my house key. Because what was relevant is that he broke my nose. There was nothing wrong with me trying to receive my house key from him.
Well, the incident happens around 3 a.m., correct?
It was about 3:38 when I took the photo of my nose broken, and that was shortly after you.
And the reporting from the hospital and the contact with police is until sometime around 7:30, 7:30, is that correct?
No, it was around 5-ish a.m. My parents had my daughter, they took her to try to get her boyfriend's lawyer to sleep.
Okay, you know that they recorded all of this and the timestamps are there.
Yeah,
Okay, you're telling me it was at 5 a.m.?
5-ish. And remember, when I saw my call log, it was 5-something when I tried to first reach out to my parents.
Okay. After you left your house, did you confront Alex at a QT gas station?
I didn't confront him. I stopped because I saw his truck was stopped. I asked, what is he doing? Just punched me in my nose. Where are you going? I need my house key. I didn't want him to come back to my home.
So Alex, who left your home, you felt compelled to go after and confront, talk, whatever it is. Did did he have your key?
Yes, he had my house key. I did not want him to be able to enter the home again.
And so there is a very heated conversation in that QT parking lot. Would you agree with that?
But I don't know how to explain heated.
And-
My
and-
face was still covered in blood. Yeah, there was a little tension.
And in that conversation, did Alex tell you, I'm going to my mother's, go home? Go home.
I don't recall.
You don't recall that?
No,
Do you recall Alex leaving the QT and driving in the direction of his mother's?
yes.
Did it become apparent to you, looks like he's going to his mother's?
He could be going anywhere towards that way because we were the further ones out. Everybody he knows goes towards that way.
But as it turns out, he went to his mother's.
Yes, sir.
Okay. And you followed the whole way.
Yes, sir.
Okay. Alex's mother knew you were coming, didn't she?
Well, I'm assuming so. She had a call from him or something. We
Well,
were in separate cars.
Was she communicating with you prior to your arrival, saying, Olivia, please don't come over here. Please just turn around and go home.
It wasn't that polite, but yeah.
Okay. It could have been more forceful, but long before you got there, his mother was telling you, trying to diffuse the situation, please just go home.
That's not, I wouldn't call it confusing, but she had told me to, I can't remember word for word, but she had messaged me, yes, about me being there, about me coming. I wanted my key back.
Do you remember telling her in the text conversation, you guys were arguing about what happened? Do you remember that?
I'm not sure what text you're referring to. I don't have anything to look at.
May I approach, Judge?
Yes.
That's why I'm going to show you what is marked for identification as defense exhibit. Don't you don't have to tell me what it is. Do you recognize this?
Yes, it is a text message between, I'm assuming his mom, it just shows my contact ID at the top.
Okay. Do you recognize that to be part of the conversation you were having with his mother when you were driving over to her house?
Briefly, I mean, I was driving, so like, was looking for a quickly scan it.
But you do recognize defendants one to be the texting conversation you're having with Alex's mother.
Do I recognize this conversation?
Yes.
Again, briefly, yes, I just got my number and I was driving looking for the window.
And so in the conversation, do you agree with me? She is telling you, trying to get away from you, do not come over.
Yeah, that looks like that's what she said.
Do you also acknowledge that in this conversation, you're telling her that you have cameras?
Yes, and then I realized later that I was not able to receive that.
Okay.
I have cameras all over the place that captured the previous assaults as well, so.
Okay.
I'm confused where this changes that he broke the news, sir.
Okay, I know you want to keep saying that, and that's fine, but
That's the.
I want to talk to you about this stuff for now, okay?
Okay,
Did it stop you from going over there? It didn't stop you, did it?
no, because I arrived and I wanted my house key.
Okay. And I guess his mother met you in the parking lot and the two of you, I guess, had your own words. But eventually you left and went back home.
Yes,
Just kind of the ending line of thought here. So you leaving your house, like your immediate thought or action wasn't, I need to call the police right now. You didn't do that, did you?
no, I took a picture so I could later call the police. I needed to get my key to ensure that he would not come back.
Okay.
That was my first thought, was what's going to happen when my daughter comes here in the morning. What if he comes back? I need my key,
Okay, so to be clear, you did not call the police.
not till I was at the hospital shortly after that, no.
And you didn't call your dad either.
Did not get a hold of them. I waited until I finally got back home, and it wasn't so much later because I didn't even know how I was getting home. I didn't put in the address. I don't know outside of San Antonio. And I realized it took me some way different way. I don't even know where. And then I finally realized I'm far.
So your immediate line of thought was, I need to go chase Alex down.
I'm gonna object to ask and answer. Your Honor.
That'll be overruled. Just one moment, Ms. Hedlund. I have your paperwork. You can appear by Zoom. But well, I mean, your client can be here, but you can be by Zoom or either appear. All right, thank you. All right, ask your question, counsel.
Your immediate line of thought was, I need to go chase Alex.
No, that was. Photo, and I was not chasing him. I was trying to receive my house key.
But, all right, but that's what you did.
That's,
You went after Alex.
I didn't go after him.
Okay, you went after your key that was with Alex. I don't know how to ask this.
It's, I mean.
You were trying to go where Alex was instead of trying to get away from him.
Objection, relevance.
All right, so this is what I need all parties to do. Number one, Cindy can only take down one person at a time. So wait till the question is asked, the complete question, then you can answer, and then wait for the answer. So what is your question?
Let's get past the QT. Okay. After leaving the QT, did you begin to follow Alex again?
Yes.
Objection, ask and answer.
All right, that'll be overruled.
And you followed Alex to his mother's home, correct?
Yes.
And he got into it with his mother, correct?
Yeah, if that's how you want to put it.
And then you finally came back to your apartment. However long that took.
I was at my home and called my parents, yes.
Okay. And so do you recall in the aftermath of all that, texting Alex? Now, you haven't called the police, you haven't gone to the hospital, you just got home, and now you're texting Alex, making fun of him about getting his mother involved. Do you recall that?
Objection, relevance.
All right, that will be sustained.
Do you recall, with regard to Alex's mother, threatening her about her grandchild?
Objection, relevance.
What's the relevancy?
Well, Judge, it is relevant because I'm trying to lay the foundation for a pattern where she's told the court there was an assault that has occurred and a massive gap in time goes by, and she doesn't call the police or the hospital, and now she's threatening the grandmother about their grandchild, and I'm trying to, it goes to her credibility, Judge. It goes to her credibility.
All right, you can ask the question.
Do you recall telling Alex's mother, you're not going to see your grandchild?
I'm sure I said that, absolutely, because the family makes me feel unsafe. I'm not going to bring my daughter around anybody like that.
And this was, you hadn't called the police yet. You hadn't
I
done
was
it.
not at the hospital yet.
All right, so, but this is your state of mind at the time, where
I still had blood on my face, sir. I was still trying to take care of my nose.
why didn't you go to the hospital?
I'm not a doctor. I didn't know right away that my nose was broken until I wiped my face.
Miss
And
White,
I can see all of the bruising. It was a little bit emotional and overwhelming to be punched in the face twice by your partner. So it takes a second for me to think, what can I do other than try to receive my key, keep me and my daughter safe, let me go to the hospital and get a CT scan and bring my family with me. I hesitated. My dad had to work. He helps provide for me. I knew my dad had to work. I knew they were going to absolutely despise Alex.
Get
Once
up.
I told them, I hesitated.
objection, please, non-responsive.
That'll be overruled. You can continue to answer.
Forgive me, but you keep asking me these questions.
Excuse me, so
I apologize.
let me just explain something. Do not address anything to the attorneys. Just listen to the question and ask the question, all right?
Yes, ma'am.
And when either attorney makes an objection, just stop speaking. I'll make a ruling. If you don't understand what my ruling means, does it mean I can continue to answer or not? You can just ask me, okay?
Yes, ma'am.
So you can continue with your answer.
Thank you. What am I supposed to be answering? I'm sorry, what's the question?
Here's the question. Here's the question. Did you hit Alex that night?
No, sir.
Never?
No, sir.
With regard to what you described as instigating the assault, I think it was around sex. Is that fair to say?
So you're asking what was the question, or I'm sorry, the reasoning as well?
Yes, it was, you guys were home from the bar. I think you said that Alex wanted sex and you didn't, and that's what upset them. Do I understand that correctly?
Yes, sir.
Sorry?
Yes, sir.
Okay. While you were out at the bar, do you remember being at the bar?
Yes, sir.
Okay. Do you remember communicating with Alex via text message that you were, for lack of a better way of putting it, very, very aroused, very, very horny? Do you remember telling him that?
Objection, Your Honor, relevance.
Well, Judge.
What is the objection?
Relevance, Your Honor. We already talked about that and he's.
All right, so we're going to go off the record for a moment. Your objection.
Relevance, Your Honor.
What's the relevancy?
Your Honor, he's, sorry.
No.
You're asking me.
Yes.
Yes, sir.
The relevance is, again, this is going to her credibility. I would like to question her regarding some messages I have that suggests that she was actually the one instigating the
All right, then
sexual
the,
contact.
the objection is going to be sustained, but get to your text messages.
Can I approach the witness?
Yes.
You're referring to this?
I want you to read it.
No, I know.
Are those text messages between you and Alex?
Yes, sir.
Okay. Can you tell me what time this message was sent?
1:42 a.m.
You remember, were you still at the bar or were you already at home?
I was far before you booked my message. Of course, there was my message 2 hours prior to when I did my house.
And what were you texting Alex while at the bar?
I don't feel comfortable publicly repeating that. As you stated, aroused.
Your Honor, I can offer it if they allow it, so the court can read it. It is embarrassing. I'm not trying to embarrass her, but I think it's important.
I'm objecting, Your Honor, to this picture, to this.
Let me see.
It's a new way of doing it, Judge, but there's defendants too. I don't think I need to draw your attention to the message on the.
All right, with regards to the defense exhibit number 2, from reviewing this, are there alleged to be any responses from the defendant in this exchange? Because I can't tell from,
State hasn't seen it, Your Honor.
Your Honor, we're gonna object to hearsay on this
Judge, they've already agreed. It's
in 412, Your Honor.
I've already offered it.
all right, so here's the thing. Number 1, lay the foundation for defense exhibit number 2, then offer it, then I'll make a decision on whether or not it should be admitted. Now, what I can tell you, I can understand certain things may cause embarrassment, but both parties agreed that this would appear by Zoom because the state had witnesses that they wanted to have by Zoom. So the questions that he's asking, if you don't want to answer what's in the text message, what's going to end up happening is the court is going to accept that exhibit into evidence, and counsel, you'll need to lay the foundation before I accept that those are her text messages if they're alleged to be your client. You know, each one that's in there. And then once that's laid, if she doesn't feel comfortable answering his questions, and counsel, if you want, I'll instruct her to answer the questions. Otherwise, I will take into evidence defense exhibit number 2 once the foundation is properly laid. So however you wish to proceed,
I
defense.
believe she has already testified that these are her text messages to Alex from that night, but I'll ask her.
Yes, not to each one.
Not to.
Yes, she hasn't testified that each one of those text messages. So what the court would need, if there's no objection to the court saying this, every text message that's in defense exhibit number 2 needs to be identified as coming from the witness. And whomever those text messages were sent to, that needs to be established as well for the court.
Regard to defense exhibit number 2. Are these text messages sent to Alex? Are these text messages sent night of the incident preceding February 8th, actually begin on February 7th, that continue into the morning hours of February 8th?
Excuse me, are you asking the date? Yes, sir, it says February 7th, it says February 8th.
And so there are 1, 2, 3, 4, 5, 6, 7 different messages that appear in the exhibit. These are all text messages sent by you to Alex, correct?
It appears so on the sir.
And text messages begin, at least this exhibit, February the 7th, approximately 11:30 p.m. The last one having been sent that Sunday, February 9th at 4 a.m. I'm sorry, Saturday, February 7th to Sunday.
These messages, we were currently together because I couldn't find him in the bar because he got hired to doing so I was looking for him. I wasn't just firing.
Okay, but these are messages all sent by you, all sent to Alex.
Yes, sir.
All right. Judge, with regard to the question I want to ask, I'm sorry I think you addressed it. You just want me to ask her about the content.
Yes, and if she doesn't want to answer, I can instruct her to answer the question, or if you just want to proceed with offering defense exhibit number 2 into evidence, however you wish to proceed.
Your Honor, the state objects to that hearsay in 412.
Well, no. My question is, how do you wish to proceed?
I'll ask.
All right.
Ms. Wise, and understand I'm not here. In the text thread, that we just discussed that we sent to Alex.
All right, we're still on the record in 2024 CR 3533, State versus Alex Neosek. Still on the oath, and defense is still your witness.
Thank you, Judge. Oh, okay. I thought she was asking me to wait.
It's your witness.
Yes, ma'am. Ms. Wise, in the aftermath of the incident, so since the day of the incident, you have not seen Alex, correct?
Except for that on Friday, he got some of his belongings. I've not seen him.
Okay. There's really not been any communication, any contact or anything like that. And this was in February the 8th, correct?
Since
Okay. In the immediate aftermath of the incident, for about a week to 10 days, do you recall texting Alex? Yeah, for about a week to 10 days in the immediate aftermath of February 8th, do you recall texting Alex?
Yes, sir.
And for about a week to 10 days, would you agree with me that it was a one-way texting conversation? You kept texting Alex over and over and over, and Alex just didn't respond.
Objection, hearsay.
Sustained.
Okay. You continued to text Alex. Okay. I want to talk to you about April the 7th. That is a day that you had come down to the DA's office to visit with them about the incident and also to visit with them about some of the details you're providing. Do you remember that day? Yes.
Yes.
Do you remember who you met with?
So, Sarah, there's somebody else I've spoken with. That's probably there's 3 women.
And do you remember how many people were there?
3 women.
Okay. And the purpose of that visit was to go over the incident with you, correct?
Yes.
And they also were asking you questions, maybe seeking information they didn't already have or details they didn't already know about, and they were asking you. Do you recall that?
Yes.
Now, we've already talked about the SD card. I believe that you testified that you remember the SD card coming up in that conversation, and you were quite clear with them. The only reason there's not a video recording was because there was no SD card.
Objection as an answer.
Sustained.
Okay. Do you recall there being a discussion about the SD card?
Objection as an answer.
Overruled. Yes.
You can answer.
I said that there was a possibility that I might be interested to retrieve something, but I'm so long with that camera and the SD card specifically in my bedroom camera, there has not been one since January 1st, as I had stated previously.
All right. With regard to any potential audio recordings, do you recall that discussion happening?
With SD cards, only carry so much storage. Trying to go back months prior, it's overwrites itself.
Okay, and I want to be very, very specific. And my very, very specific question is this, Ms. Wise. Did you tell the prosecutors and the advocate on April the 7th, when you were meeting with them about the details of this incident, that you had an audio recording of the incident?
Objection as an answer.
That'll be overruled.
to say yes, it was a possibility. I will check it. I was not able to check it, so.
Okay, so your memory is, you told the prosecutors you might have an audio recording.
Yes,
Okay. With regard to these videos that we're talking about, how many cameras were in your apartment that could have recorded or gathered audio or visual information?
one that would be able to review it going back would be the living room one. The first, if we're on our bedroom, you cannot pull up any previous storage on that one. You have to look at it from a live view of the baby monitor.
Okay. There are 2 cameras in your apartment, correct?
Yes, sir.
And the cameras are linked to an app, correct?
Yes, sir.
And the only person that had the app or access to the app is you.
Yes, sir.
And so, sort of like a Ring camera. Now, these are not Ring cameras, but sort of like a Ring camera. They send videos to your phone, correct?
If I try to like review it, nothing gets sent to me. I can pull back up though.
Right.
After so much time though, you cannot. It's the SD card is a limited space.
Understood. And the person that has complete control and access to all of the content, audio or video, is you.
Yes, sir.
All right. Alex didn't have any control of any of that, did he?
No, he never asked for the loan.
Okay, Your Honor, for now, that's all the questions I have. I'll pass the witness.
Just a few more questions, Your Honor. Ms. White, why are we here today?
Alex punched me in the face and that was a violation of his building.
Okay, can you identify, is the defendant here present in this courtroom today?
Yes, ma'am.
Can you please point him out by clothing?
Is there any straight collar photo at the table? That's position.
Okay, thank you. Let the record reflect that the complainant has recognized the defendant. Ms. Weiss, do you still fear the defendant?
Yes, ma'am.
And why is it important to you that the court or the defendant is held accountable for what he did?
Judge, I'm going to object. This is not relevant.
Sustained.
Okay. No more further questions, Your Honor.
Any further
No,
questions?
no additional questions, Judge.
Is this witness excused?
Yes, Your Honor.
I mean, I would say for now, if we could keep her around, Judge, I might have to recall her. I'm
Right,
sorry.
if you'll keep the witness available today for recall. State, call your next witness.
With the state rests, Your Honor.
Defense, any witnesses?
Yes, Judge. Judge, can we approach briefly?
Yes.
I would need to be calling her as a witness. Brief conversation about that. My understanding is that her advocate, Sarah, was also there, and she informed me that I could utilize her if I needed to call her.
Who do you want to call?
It honestly does not matter to me.
No, I mean,
The advocate,
whoever you want to call.
You have to go to the proper channels of opinion.
This is a rebuttal witness, Judge.
No, who do you want to call?
Sarah.
Who is the Sarah person?
Yeah.
All right, can you have Sarah come down?
Well, Judge, I was here wanting that she be made available to me as well.
Proper channel still to be followed. Your Honor, he needs to subpoena Sarah if he wants her down in court.
All right, did y'all tell him that she would be available?
Yes.
Not a party to that
All right,
conversation.
have Sarah come down to court. And if somebody from the appellate section wants to file a motion that she should not be allowed to testify, then y'all can do that. But tell Sarah she needs to come down.
I'm texting right now.
All right, thank you. Anyone else you want to call other than Sarah? Did you want to call Ms. Jones as well?
I don't believe that I will have to, Judge, so no.
And where is Ms. Jones?
I believe she's upstairs too.
Have Ms. Jones come down as well.
Yes, Your Honor, text them both.
All right, and then we're going to take a short recess from this and I'm going to take up other matters.
Yes, Judge.
Thank you. Eddie Baldwin. All right, the court is calling 2026 CR 0000656 2 State versus Eddie Baldwin. Can I have parties announced?
Lauren Espinoza for the state. And Valerie Headland for Mr. Baldwin.
I'm so sorry. You're gonna have to take that to the court, yeah.
Oh, yeah.
And are you Mr. Baldwin?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Baldwin, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
Yes.
State, are you proceeding on the indictment as presented?
I do believe so, Judge, yes.
Mr. Baldwin, did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, to charge with the offense of robbery, that's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Baldwin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 4 years in the prison. There's a $1,000 fine probated. The state recommends community supervision. They're taking in consideration 2025 CC 016045. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be 100 hours of community service restitution, no contact with Judy Apolinar or any Cricket Wireless in Bear County, MRT, and the felony theft course. Did you understand those are recommendations from the state?
Yes,
And
ma'am.
the court does not have to follow those recommendations.
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offers States Exhibit 1 in all attachments. No objection.
All right, state, you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call and the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. After reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client?
No, Judge, he was in custody for quite a few minutes
Yes,
before
ma'am.
you pointed out. So I think he's had plenty of time to reflect, and I think he's gonna do well on probation.
Why did you do this?
I was on drugs. Yes, ma'am.
So are you living with someone? Do you live by yourself?
I live with my mom.
Okay. Do you have any children?
I got one, a
Right.
son. Yes,
And
ma'am. He's
age?
5 years old.
Okay. How far did you go in school?
I made it to the 10th grade.
Okay. Have you obtained a GED or
No,
anything?
ma'am.
When's the last time you had employment?
I'm employed right now, but before I got locked up, at this time I was with UPS, and then when I got with them, I got locked up and they fired me. So as soon as I got out, I started working with my brother doing general labor, and I've been with him ever since.
All right. And I'm assuming UPS is not gonna hire you again?
No, ma'am.
Okay. All right. The court is gonna sentence you to 4 years in the prison, suspended and probated for 4 years. There's regular reporting by Zoom or in person,
Yes, ma'am.
regular random UAs, proof of employment within 40 days, no employment as a home health care provider or minors, and what drugs were you addicted to?
I was on methamphetamine.
Okay.
Yes, ma'am.
All right, we'll do a referral to felony drug court. And that can be out of custody. And if not accepted to felony drug court, then do a TAP evaluation out of custody, follow recommendations, but if they recommend inpatient treatment, we'll start with outpatient treatment. Taking consideration 2025 CC 016045. There is $1,000 fine, probated. No contact with Judy Apolinar. Do you have service with cricket?
No, ma'am.
All right. Is there any need to ban him from all crickets? Do you have a cell phone?
Yes, ma'am.
Who is it? What's the?
Metro PCS.
All right. All right, there's to be no contact with the cricket at that location.
Yes, ma'am.
And that is, let me see.
Address if needed, Judge.
I can provide the address if needed.
Oh, yes, please.
2118 South Zarzamora, number 450.
You said number 450?
Yes, ma'am.
Do you have the zip? Is it 78201? All right, wait.
Yes.
78201. So you're not to go to that cricket, okay?
Yes, ma'am.
There's going to be 100 hours community service restitution. And 25 hours will be deducted. I'm sorry, not 25, 50 hours will be deducted if you obtain your GED or some type of trade school certification.
Yes, ma'am.
The remaining hours will be deducted at 1 hour per completion of sober support meeting. Field visits 1 time per month for 8 months. And are you going to remain living with your mom?
No, ma'am.
Okay. Make sure that you provide stable housing to probation. If there's an issue with stable housing, you need to let them know about it.
Yes, ma'am.
The felony drug court will be really great for you because they can help you with that.
Yes, ma'am.
And then you could see a lot of people stay at Tiny Village in San Antonio. I think it's called Twin Towers or Tiny Twin, something of that nature, but you can Google it. All right. Probation, is there anything else?
No, Judge.
Is there anything else you need from the court to be successful?
No,
All right. If you need anything, be sure to let probation know and just be honest with felony drug court because I think that would be a good placement for you.
yes, ma'am.
All righty. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to your attorney, okay?
Yes, ma'am.
And it's called Town Twin Village.
Yes, ma'am.
And at the Town Twin Village, you may not be in the age category because they have certain restrictions. And I think it's sort of like people in their 50s. However, they do have a place where people are homeless.
With their
You get
children.
laundry, your laundry done,
Yes, ma'am.
you can take a shower. And I think they allow you 10 minutes, which other places, they tell me only allow 5.
Yes, ma'am.
And they provide meals, 3 meals a day.
Yes,
Okay.
ma'am. Yes, ma'am.
All righty. All right, well, good luck to you.
Thank you so much.
You're welcome. Have a good one and just stay in touch with probation, okay?
Yes, ma'am.
I told him that's the worst thing you can do is just fall off the radar, so.
And trust me, those are crabs in those crab cages.
Yes, ma'am.
All right.
We be able to use.
Okay. On Joshua Sutherland. All right, so you all are up for trial.
We're ready, Your Honor.
So, all right, so I'll need y'all here tomorrow at 9 a.m. because this hearing is taking longer than anticipated.
Okay.
So Ms. Ferguson will give you a reset.
Okay, thank you.
Thank you. Marcos Rios.
Present, Your Honor.
All right, council, I'm gonna need y'all back tomorrow at 9 a.m. A jury I held on to this jury, so they'll be back at 9.
Okay.
Yes.
We don't sign anything, do we?
No, your client is in custody?
No.
Oh, he's on bond? Yes, you'll need to sign a reset.
Okay.
All right, and then Ray Cordova.
I don't think defense counsel ever showed up.
All right,
Bridget Garza?
Norma. Yeah, I know. With that one, is she gonna be available anytime this week? All right, recall him for next week. The defense attorney had an emergency.
Oh, understood.
What date? All right, so Mr. Cordova, don't leave until you sign the reset form. Jesus Suarez Marino, that's gonna be tomorrow at 9, and Norma, he needs to be brought over dressed.
He's on bond there. He's
on bond?
just
all
on
right.
the reset form.
All right, just sign the reset form.
Yeah.
Jesus Alanis Zarate.
He's in custody, Judge.
All right. I'm gonna have y'all come back at 9. This hearing is taking longer than anticipated. So I'm expecting the jurors to be up here tomorrow at 9, all of the jurors, because I'm just recalling them to come back.
Okay.
So we should be ready to go at 9.
That's wrong.
Thank you. Sorry. Andre Middlebooks.
It's already reset, Your Honor.
Okay, thank you.
To June.
Oh, June 16th.
Yes, Your Honor.
Jonathan Pomerantz, see you tomorrow at 9 a.m. Nicholas Vaquera, 9 a.m.
See ya. He needs to sign a reset form. He's out.
All right, thank you. Michael Balderas, tomorrow at 9 a.m., and that's number 1. Robert Porter.
I'm here, Judge.
Hi. All right, Mr. Porter, on your case, we'll recall you all back tomorrow. And let's see, but you all are not number 1. There's another
My
case.
wife usually calls me number 2.
Okay. All right, Reyes.
Present, Judge.
All right, the court is calling 2026 CR 0000976 State versus Reyes. I'm sorry.
Sorry, good, Your Honor.
All right, could I have parties announced?
Lauren Espinoza for the state.
Robert Ferris from Mr. Reyes.
And are you Mr. Reyes?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Reyes, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Reyes, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Reyes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
I understand, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's $1,000 fine probated. State recommends deferred adjudication. This run concurrent with 2025 PF 37473. Did you understand that to be your plea?
Yes, Your Honor.
Defense and state?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There'll be 120 hours of community service restitution. No contact with 12280 State Highway 16 South, San Antonio, Texas 78224, MRT and the DOEP. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
Yes, Your Honor, state offers State's Exhibit 1 in all attachments, and also regarding that PF number, I have the filed CC number for
All
the
right.
court.
Yes, and what is that number?
2026 CC 006893.
Any objection to the court writing that in the plea?
Okay.
All right, so you say 226 CC 006893?
Yes, Judge. Thank you.
You're welcome. All right, and then state you're offering into evidence
State's Exhibit 1 in all attachments, Judge.
and no objections?
No, Judge.
All right, state you may be excused.
Thank you.
Thank you. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client? So this location, what's the name of this location?
It's for flea market.
Okay, because they were talking about a dance floor. Is there,
This one.
oh, so it's the dance, they have dance?
Yeah, it's like a flea market where everybody goes and like they got like their own dance floors.
Okay, because I was trying to, because I didn't see the name. So what else do they have at this flea market other than the dancing?
I just go shopping by like clothes or food.
All right, and what time is this alleged to have happened? Was it during the day or?
I really do not remember, Your Honor.
Okay. So this is a possession less than a gram case. If you're drug tested today, what would the results be?
Negative.
Why does it take you a long time to say that?
Sure.
So here's the thing, I need you to tell me the truth because I can tell you right now, I'm gonna follow your agreement, but your attorney will tell you, I'm trying to give you conditions that are gonna help you. So if you're gonna be positive, let me know because they're gonna drug test you.
No, Your Honor. I won't be positive.
If you even think you're positive, it's okay to say so.
No, yeah, I understand, but I'm positive that it's gonna become negative.
I'm sorry, what?
I'm positive it's gonna come out negative.
Oh, okay. So when's the last time you used?
I believe like it's been a month or so. Because I was out of stage working.
Okay, and do you, oh, what do you do?
Construction.
Do you have any children?
No, man.
All right. So state, with regards to this no contact, he's telling me that location is a flea market.
Yes, Judge.
Do y'all have any objection to him having contact during the daytime? I don't know what time this dance happened.
Through the report time, Judge, was 15:33, which would be, what is that, afternoon
Three,
time,
yes,
3
3
p.m.
So,
But whatever the court sees fit is fine.
well, I can do you can have contact with that location, because I know with the flea market, sometimes people go there to buy things. But it'll be from, what time does the flea market open?
Like around 9 in the morning.
9? So it will, I'll say like from 9 to 12, you can have contact, okay? But don't go to the dance floor.
Understand, Your Honor.
All right. Okay. This is what the court is gonna do. There's $1,000 fine probated, concurrent with 2025 PF 37473, which is the same cost number as 2026 CC 006893. Regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. And with regards to the regular random UAs, he can do that or do the patch. Sometimes the patch doesn't work well if you're working in construction because of the heat. Your attorney can explain to you about that. There's 120 hours community service restitution. I'm going to order the DOEP course. Once that's completed, 60 hours will be deemed satisfied. The remaining 60 hours, there will be an hour deducted for every completion of the sober support meeting. There's allowed contact Monday through Sunday. Well, I'm sorry, I'm just going to say daily contact from 9 a.m. to 12 p.m. at 12280 State Highway 16 South, San Antonio, Texas 78224. There's a TAP evaluation out of custody. Follow Rex. But if it says inpatient treatment, start with supportive outpatient treatment. Probation, is there anything else?
For those hours that you can't enter that location, that it's allowed to enter, can you give me those hours one more time?
9 a.m. to 12 p.m.
And field visit,
We'll do field visits one time per month for 3 months.
nothing else, Judge.
All right, is there anything else that you need from the court to be successful?
Sorry, Your Honor.
Did you, and I'm sorry, no possession of firearms. And the reason why I'm doing that is because you have an unlawfully carrying case in misdemeanor court, I'm assuming. All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, Your Honor.
All right, good luck to you, okay?
Thank you, ma'am.
Thank you. You're welcome. Let's see. Courtney Price. Hello. How are you doing today?
I'm well.
All right, so, I'm sorry?
My attorney is in here.
No, he's out of the country,
Oh, okay.
so. But State, you have the discovery on medicals?
Yes, those are in, and those have been tendered to Mr. Garcia.
All right, so, and was an offer tendered?
An offer has been tendered, yes, Your Honor.
All right, so Norma, set this for a plea deadline date and a jury trial date mid-May. And Family Collins, are you all on all of these cases?
Yeah, Judge, the DCD has the remaining, Judge.
All right, because
If I may suggest, Your Honor, there's like a hybrid family violence dispute trial we can lay on May 26th. Can we have that?
yes. Who's calling me?
Sorry, Judge, I didn't mean it. Okay.
All right, Norma, they're asking for May 26th. All right, so we're gonna bring you back on May 26th, okay? Your attorney will be back here well before then to speak with you.
Okay.
And if he has any issues about that date, then the court will take that under consideration. All right, do you have any questions about anything?
No, Your Honor.
All right, thank you. What page? Melinda Gonzalez. Hello, good morning.
Joseph Acevedo Jr. here for Joseph Acevedo.
Thank you.
All right, brother, thanks.
So if I may, we were actually just hired on this case this morning, and so we're asking for a reset. So we can go over everything with this control.
Okay, just 1 second. Let me see how long this has been on the docket.
This might be her first setting for this MTR. I think from my understanding is correct, she's bench warranted from the other counties.
All right, Norma, set this in 10 days for a contested hearing. All right, y'all need to be back here May 7th, contested. All right, thank you.
Thank you, Judge.
You're welcome. All right, Arojo. Norma, on Arojo, you said he broke his ankle or something? All right, so your attorney has a broken ankle. As we get older, things just happen. You take a step down a stairway, you don't hit it just right, you break an ankle. And that's just what happens to men. Women, we're okay.
All right.
Yeah.
He's all right though?
Oh, he's okay. I mean, except for a broken ankle. He's okay. I think he's gonna be okay. You know, I always tease people and say, now, if a woman had broken her ankle, let's say if a woman had broken her ankle at 2:30 today, she would already be back at work. So a guy, he breaks his ankle, it's like, I need to be out for 2 years for it to heal. So we're gonna recall you for a plea deadline date. Norma, put this for a plea deadline date at the end of May, please. Does the 26th work for you?
Yes, ma'am.
Are you employed?
Yes, ma'am.
Is that gonna interfere with your employment or that gives you enough time?
It is, ma'am, but y'all close before 5 break.
Well, no, I mean, I'm here till 5.
It is, ma'am, but I'll have to.
Right, well, I mean, if you want to appear by Zoom, you can appear by Zoom.
Oh, if I can do that, ma'am, that'd be great.
All right, Norma, he can appear by Zoom. All right, once you sign the reset form, you excuse. Thank you. Thank you for addressing appropriately for court.
You have a good day.
You too. Oh, so are you ready?
Ready.
All right, today is the plea deadline date. So have you all come to an agreement or is this going to be a jury trial?
No, Judge, we actually like to get a short continuance. I've been talking to the state and there's some underlying issues that we want to talk about. And also the possibility of maybe filing a motion to suppress. And so this case, I just don't want to say too much, but there is something that it's underlying these cases and the co-defendant that we need to try to
So
figure
are you
out.
all going to have a motion to suppress? Is it going to be dispositive or not?
I think so, Judge, yes. But there's the other issue too, that is.
All right, Norma. Set this for the week of. You know what, Norma? Just set this on. Just 1 second. Make sure, okay. Norma, can you set this for a motion to suppress on May 20th? Are we here? Yes. All right, motion to suppress and plea deadline date is May 20th.
May 20th. Okay, Judge.
All right, is there anything else?
Nothing else.
Anything else?
That's all.
All right, thank you.
Gracias.
Bye. De nada.
Maybe excuse.
Yes, thank you. All right, you two have a good one. All right, Ledesma.
Where you are?
Court is calling 2022 CR 6907B State versus Isaiah Ledesma. Could I have parties announced for the record?
Lauren Espinoza for the state.
From reporter for Mr. Ledesma.
And are you Mr. Ledesma?
Yes, ma'am.
All right, Mr. Porter has been appointed to represent you, and he was just appointed to represent you today. Your attorney does have certain rights, or I should say you have certain rights through your attorney, and one of them is notice and a chance to prepare. So I can reset this case so your attorney will have more time, or we can proceed today. Which would you prefer?
C2.
All right, and
Okay.
defense? Okay. All right, Mr. Ledesma, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Isaiah Roman Ledesma who was placed on deferred adjudication in 2022 CR 6907B for the offense of robbery on October 18, 2022 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bexar County, Texas, the defendant Isaiah Roman Ledesma did then and there fail to report to the supervision officer as directed for the month of December 2022 in violation of condition number 4.
I just want to make sure, Judge, that's going to be on the First Amendment.
Oh, it's the First Amendment?
Yes, Judge.
All right, I don't have the First Amendment. All right, did you review the First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes.
All right, state, you may continue.
Okay, violated condition number 4. In Bexar County, Texas, the defendant Isaiah Ledesma did then and there fail to report to the supervision officer as directed for the month of January 2023 in violation of condition number 4.
All right, how do you plead to that, true or not true?
True.
Violated condition number 4 in Bexar County, Texas, the defendant Isaiah Roman Ledesma did then and there fail to report to the supervision officer as directed for the months of February, March, April, May, June, July, August, September, October, November, and December 2023 in violation of condition number 4.
How do you plead to that, true or not true?
True.
Finally, violated condition number 4 in Bexar County, Texas, the defendant Isaiah Roman Ledesma did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, and October 2024 in violation of condition number 4.
How do you plead to that, true or not true?
True.
State will waive the remaining allegations.
All right, and that's a violation of number 4, is that correct?
Correct.
All right, any objection to the waivers?
No, Judge.
Did you understand by pleading true to those violations, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 4, 4, 4, and 4?
Yes.
Court will find 4, 4, 4, and 4 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to grant state's motion, enter an adjudication of guilt, revoke supervision, and sentence to 6 years TDC to run concurrent with Guadalupe County Cause number CCL 250532.
Is that the agreement?
That is our agreement, Judge.
Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, so I have a question. Probation. It says that there is to be restitution to Isaiah Miramontes. Was there any restitution ever ordered?
No, Judge.
Okay. All right, this is what the court would do. The court is going to find you guilty, grant the motion, sentence you to 6 years in the prison. This will run a concurrent with Guadalupe County County Cause number CCL 250532. There's to be no contact with Malik Lampkin, Jennifer Trevino, or Isaiah Miramontes. There's to be no residing in households with minors and no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Make better choices.
Judge, one thing I just wanted to make clear, and I think the clerk has already change that. This MTR was,
Just 1 second. Cindy, we're still on the record.
Okay.
Go ahead.
this MTR was filed, the amended one in May. He'd been in Guadalupe County for some 15 months already.
Mhm.
Jail. And when he took his plea, it was on his accord that he actually wrote the district attorney's office a letter saying, hey, can we do something about this? I wanted to make sure he was gonna get the credit for the 15 months that he had sat in the jail under this case. You know, that the numbers we're talking about over here.
Okay, so let me ask you. The original motion to revoke, not the amended, when he was in custody, had that already been filed or no?
The original one was filed back in.
I'm trying to look at it.
2/25/26.
It was February 28th, 2022,
Okay, and so February 8th, when?
of 2023.
All right, and so when was he in Guadalupe?
Then he got picked up in November 2024. And
Yes.
since from 2024 to present, he has been incarcerated.
So yes, he'll receive all that time.
Thank you, Judge.
All right, and they'll just make sure that the clerks have it correctly. If for some reason, when you're transported, you'll see what your time is. If for some reason you feel like it's not correct, just let us know, and it'll be easily corrected. But the clerks should know how much time. And counsel, once they do the judgment, if you want to bring it back to me if you have any issues. And so we'll be able to know, okay?
Yes, ma'am.
Do you have any questions?
No, ma'am, thank you.
All right, you're welcome. Good luck to you. All right, we're gonna go back on the record in 2024 CR 3533, State versus Alex Miosek. Could I have parties re-announced for the record?
James Tochi from this class.
Oh, your client needs to be.
Yes, ma'am.
All right, Mr. Toshi, call your witness.
Judge, before I do, while we were on break, there was an issue regarding one of the DA employees testifying. I've conferred with the state and we have an agreed stipulated item of evidence I'd like to offer the court. It's identified as defendants 3, and I'll share with the state right now.
All right, so to the state's attorney, did the other male attorneys who came down here, did they go over that stipulation with you before?
Yes, Judge.
Okay.
We'd like to offer defendants 3 into evidence, Judge.
All right, any objection to state's exhibit number 3?
No, Your Honor, we did talk to the defense and we informed him that if he wanted to have the advocate or the other witness here, he had to go to the proper channels of subpoenaing the witnesses, and we agreed to that stipulation, Your Honor.
All right, so I'm gonna let the record reflect, and if anything that I'm putting on the record is improper or misheard by the court, let me know. My recollection is that Ashley Jones, is that her last name?
Yes, Your Honor.
Yes, Judge.
Ashley Jones, the first year prosecutor, was down in this court assisting with this motion to revoke. The advocate was brought down with her. There was a conversation. I was in the room with the conversation. Mr. Toshi was here. The prosecutor was here. And my understanding from Mr. Toshi is that either Ms. Jones or the advocate would have been made available for him to call as a witness if he chose to call them as a witness. Is that correct? Yes or no? If it's not, tell me.
It is more or less. I had a conversation with Ms. Jones after we broke, and I told her I'm going to need her to testify. She had indicated her desire not to testify, and I explained the reasons why, and she had informed me, the advocate was there. If you need to, you can call the advocate. Now, I don't know if she was being tongue in cheek with me, but that was
tongue in cheek in the middle of a hearing.
We're off the record and just, and so I did communicate via text on the break, please have the advocate available. I'm going to need to have somebody testify, anticipating these issues would occur. I did confer with several representatives of the DA's office and my client. I'm comfortable with the stipulation that we have here, and the information is now before the court.
All right, and so, and where is Ms. Jones?
She's currently not here, Your Honor.
So we start hearings, but we don't finish them. Okay. All right, so Mr. Miasek,
Yes, ma'am.
if you can come forward. According to the law, your attorney has the right to at least attempt to have witnesses here that he would like to have here in your defense, or just witnesses he feel to call. So two of the witnesses he wanted to call, or either one of them, was either the prosecutor, Ashley Jones, or either the advocate, and what's the advocate's name?
Sarah Herrera, Judge.
Sarah Herrera. Now, he is informing the court that the state, with two male attorneys that they brought down who were not a part of the hearing, but they brought them down, have decided to stipulate to certain testimony. So what that means that your attorney is no longer seeking to have witness Sarah Herrera or Ashley Jones called as witnesses, where he would have a chance to question them, and the state would have the chance to cross-examine them if they so choose. He's decided just to accept this stipulation. The state is saying that they're not going to object to this stipulation, so no one is going to have a chance to question this witness, which is the victim advocate, Sarah Herrera. So the question is, do you have any objections proceeding with just this stipulation and not having the witness brought down here to be questioned by either your attorney or the state's attorney?
I mean, I would feel like if there's a witness to it, I would want them present.
You want to speak with your attorney?
Well, I mean, we have had a conversation about this. I did inform him of the stipulation.
Well, let's do this. You all can place whatever you want to place on the record. Then defense, you're offering the stipulated evidence that is defense exhibit number 3.
Yes, ma'am.
And no objections?
No objections, Your Honor.
All right. Thank you. If you could give that to the court reporter, I've read it.
Yes, ma'am.
Then defense exhibit 3 will be admitted into evidence, and you all may take your seats. Mr. Toshi, call your next witness.
Judge, I'd like for Mr. Miasek to take the stand.
All right, if you'll take the witness. All right, if you can raise your right hand. You solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God. All right, you can lower your hand. Please keep your voice up so that I can hear and everyone else can. State your name for the record. All right, defense, you may proceed.
Thank you very much. Alex, can you spell your last name for the record, please?
MIOSSEC.
Okay. All right, Alex, let's just kind of cut right into this thing. Obviously, we've been here for a while and we've already heard from Ms. Wise. I want to just go right to the day, February the 8th. Do you recall that day?
Sure.
And do me a favor, Alex, can you speak a little bit louder? I'm having a little hard time hearing you. Okay. Just to give a little bit of background, where did that night begin? Where were you and who were you with?
We were at a coworker of mine's birthday party celebration. It was at their apartment complex.
All right. How many people were you with?
Probably 50 or more at one point.
All right. Towards the end of the night, did the group of 50 kind of whittle down into a smaller group?
Yes, from there, it's probably like 5 or 6 of us, maybe.
Okay. And were you with Olivia Wise?
Yes.
All right. That night, let's kind of pick up from about midnight on. Where were you?
We were at Camp 1604 and Kung Fu, kind of popping around. There are 2 bars that are right next to each other.
Okay. In your estimation, kind of what was the mood of the group that was there, including yourself?
Yeah, it was good. Everything was going good for the most part. Say Olivia was at one point she was a little cranky about not being able to find me because I was socializing. I kind of got over that, and then she kind of turned into the mood of, she was kind of in the mood of having sex and stuff later on.
Okay, well, we'll get to that here in a second. Had Olivia been drinking?
Yes.
Okay, a little or a lot?
I guess I would say a fair amount.
Okay.
I wasn't counting.
Sure. She wasn't like fall down drunk, but did she have a good buzz to your?
She was pretty intoxicated. She was-
Objection, Your Honor, speculation.
All right, that'll be sustained as to speculation, if you can lay the foundation.
Well, I mean, how many drinks would you say she had?
We had been there for hours, so say about 3-4 hours.
Objection,
worth of drinking.
speculation.
Overruled.
Go ahead, Alex.
Yeah, I would say about 3 or 4 hours worth of drinking from where we were before to when we ended up at the bar.
All right. Now you mentioned, and this has come up and you've been watching, did Olivia want to have relations with you that night? Did she want to have intercourse?
Objection, hearsay.
Of course.
All right, so here's the thing, when objections are raised, you need to stop talking so I can rule on them. Ask your question, please.
Did Olivia wish to have intercourse that night?
Yes.
Objection, here.
Sustained.
Judge, I'm not asking for a hearsay response.
The objection is sustained.
Okay. Without telling me anything Olivia may have said, what gave you the impression she wanted to have sex?
She texted.
Objection, speculation.
With regards to speculation, that'll be overruled.
Okay. And she's already told us about the text message. Was her behavior consistent with what she was texting you?
Yes and no. She was going back and forth between being a little kind of wanting to have an altercation, but then she would go back to being back in the mood.
Okay. What time was it that you guys left the bar you were at?
I would say closing time.
And when I say you guys, I mean you and Olivia. You were there together, correct?
Yes, sir.
When you, what time do you think it was when you got home?
3-ish, I would say. It's
How-
a good 45-minute drive home.
Okay. Olivia doesn't live in Bear County?
No.
Okay. Let's kind of pick up there. Now you're home. You guys have been out at a bar. What kind of transpired once we're home and settling in?
Well, I was already getting ready for bed. I was already laying down in bed. And I was kind of on my phone when we first did get there, though. She was obviously in the mood. So she was kind of grinding on me, telling me what she wanted to do. I was laying down in bed, I was on my phone. That caused her a little bit of frustration. Because her words were, you care more about your friends than, me trying to sleep with you right now.
Okay. So when you got home, Olivia was interested in sex. Were you?
Yeah, wasn't against it.
Okay. And where were you? Like, where was this taking place?
I was laying down in bed on my side of the bed.
What were you wearing?
I think I was just in my boxers, honestly.
Okay. Do you recall what Olivia was wearing?
One piece.
One.
Got like a one piece, like not lingerie, but just like a one piece.
Okay.
button up.
Okay. And so let's talk about this critical part. Like, how did we go from that to this incident? Like, what do you recall Olivia doing?
Well, she was frustrated because I wasn't really paying attention to her. So she got up, went to go get water. She was about at the end of the hallway. I was laying in bed. She just started arguing with me, and words were exchanged between both of us. And she just kind of kept trying to bring up what she wanted to fight about originally, which was pointless. So in that, I did yell back at her that, you'd be a lot cooler if you would just quit your bitching. Like, how about you, shut up. And I
Okay.
did say that, yes.
Okay. Well, I wasn't asking you about anything you said.
Yeah.
Did you ever leave the bed?
No.
All right. So the two of you came together by her coming towards you, is that correct?
Yeah, she jumped off that.
All right. Was she on the bed or was she on you? Like, kind of, how was she physically positioned?
She was like hovering over me, like on her knees over me.
Okay.
Not quite on top of me, but like just right over me. I was laying down on my back.
All right. Did you ever move? Were you just laying there the whole time? Okay. And so did there come a point in time where Olivia started to get physical with you, and not a romantic physical, more of a violent physical?
Objection leading.
Sustained.
Okay. Well, during this interaction, did Olivia do something?
Yes, he hit me repeatedly in the face.
Okay. With?
All right.
Do you know why?
Because I had said what I said.
Okay. You said something that made her mad.
Yes.
Okay. How many, so is she straddling you? Do you, or
Yeah,
she,
that would be-
and when I say straddle, you know what I mean, right? Like she's on top of you.
She wasn't fully on top.
Okay.
She had one leg on, like one leg over one of my legs.
Okay.
I was laying on my back, so she had her leg over my right.
So she started hitting you.
Yes.
With?
Her hand.
How many times?
Say probably 4 or 5 times at least.
Okay. Was it with an open hand, a fist? Do you recall?
I do not recall. But it didn't feel like she was punching. Yeah.
Okay. Can I approach the witness, Judge?
Yes.
Alex, I'm going to show you what the mark for identification states. I'm sorry. Fence exhibits 4 and 5. You recognize those? All right. How do you recognize those?
That's me in the pictures that I took shortly after the altercation.
Okay. When were the pictures taken?
A minute after.
Do they fairly and accurately depict the way you looked on the day of the incident that we're discussing right now? Your Honor, at this time, I'm gonna offer amendments 4 and 5 in. I'll share with the state for inspection and objection.
No objection.
Right. Fence exhibit 4 and 5 are admitted without objection.
Okay, Judge, and I'm just, if it's okay, I'll share with the court, but I'm gonna just if you can briefly, with regard to the defendants 4 and 5, Alex, what are we looking at there? What injuries do you have?
So right here, there's first one you see is definitely my eye. I was poked in the eye during her hitting me. There's clear red marks on my ear, neck, and handprints across my face.
Okay. What did you do?
I did put my hand up, to kind of like create some distance. Didn't work, so I did try to like pull her off of me, which is where I believe like her shirt got ripped, which that really irritated her even more, so she continued hitting me.
When you, let's back up a little bit. When you say you raised your hand up, I mean, did you make contact with her face?
I don't believe the first time when I put my hand up, I was still continuing being hit, so I tried to pull her off.
Okay. Did there come a point in time where you used your hand and you did make contact with her?
Yes, the second time after her blouse, whatever she was wearing, had ripped, she continued hitting me, and that's when I kind of put my hand up and sat up to kind of create the distance, and then.
Okay. So you made contact with her.
Accident.
Well, it wasn't on accident. I mean, you're trying to get her off you, right? Okay. And did you notice she was bleeding?
Shortly after she got up, and that's when she pointed out that she was bleeding.
Okay. Was there anything that she did that you may have found a little odd with regard to the blood that was coming out of her nose?
Well, yeah, I mean, she noticed her nose was bleeding, so she continued to cuss me out, and her exact words were, well, since you made me bleed, I'm gonna make you wear it, and she started blowing.
Objection, hearsay.
Okay, don't tell me anything she said. I just want you to tell me what she was doing.
Blowing her blood towards me.
Okay.
Like a farmer's blow, like blowing it towards me.
Understood. What did you do at this point, Alex?
I I told, I mean, my exact words were, okay, like, that was an accident, you need to go clean up, and I immediately, when she walked away, I went to the bathroom, took these pictures, grabbed my shower bag, and I left.
Okay. Once you left the apartment, where were you going?
Going to my mother's house.
Where does she live?
She lives Callahan and Babcock. About 30 minutes.
How far away is that from Miss Wise's apartment?
About 30 minutes. 30 minute drive.
All right. Did you stop anywhere after you left?
I did, yes. I needed to fill up. I was on ED, so I stopped at the Quick Trip on 3009 and 35.
Okay. And while you were there, did anything happen?
She showed up. Surprised.
Okay. Now, again, don't mention anything that she said, but what was her demeanor? How was she acting?
Very aggressive. Jumped out of her car directly towards me, got in my face.
All right. Was this a pleasant conversation or was it hostile?
It's very awesome.
Okay. How long did it last?
Maybe a minute or two until pulled the gas pump out, put it back in, and got in my truck.
Okay. At that time, did you inform her where you were going or tell her where you were going?
Yes, I told her I'm going to my mother's house. It's not going home.
Okay. After you got in your car and left, what did she do?
She followed me all the way to my mother's house, pretty much like tailgating me the whole way.
Okay. Now, don't tell me anything your mother may have said, but were you communicating with your mother at this hour?
Yes.
All right. How were you doing that?
I was on the phone with her.
Okay. Were you texting your mother or on the phone or both?
I was on the phone. I was texting.
All right. Did it become apparent to your mother that you were headed home and Olivia was following?
Objection, speculation.
Sustained.
Okay. So Olivia followed you all the way home.
Objection, leading.
Sustained.
When, when you were driving, was there anyone behind you?
Olivia Wise.
All right. And when you got home, who was there with you?
She pulled up right behind me. I parked.
When you got to your mother's house, did you engage Olivia? What did you do?
I parked my truck, actually drove around the apartment complex a few times when my mother came out because I did not want to give her the opportunity to get anywhere near me. My mother was outside of the apartment. I pulled into her area, to her building. I parked, I got out, and I walked towards my mother to go to her apartment.
Do you know if your mother was engaging Olivia in conversation or dialogue or anything?
Objection, speculation.
If he knows, Judge.
All right, I'm sorry. So once objections are raised, you need to stop talking. Counsel, if you'll re-ask your question, please.
Do you know if your mother engaged Olivia in dialogue or any conversation?
All right, your objection will be overruled.
Yes.
Okay. At some point, did Olivia leave?
Yes, after they exchanged words.
Now, from the moment this incident took place at about 3 o'clock in the morning on February the 8th, if I have this date right, how many days went by, Alex, before you made any attempt to communicate with Olivia? Do you recall?
The exact number of days, no, but it was a few.
Okay. 4 or 5, 7 or 8.
Give or take, yeah, probably 7 or 8.
Now, during this time, was Olivia communicating with you?
Yes.
Often? A lot?
Objection, leading.
Sustained.
Okay. How often was she communicating with you?
Daily.
Okay. Was she sending you a few or several texts? And you were not responding at all? Okay. At some point in time, did you finally reach out to Ms. Wise? Okay, and was that for the purpose of your child?
Objection leading.
Sustained.
Sorry. Why did you reach out?
Because she kept blowing up my phone, so I eventually responded. But
Okay. And I think we all know this, but you and Ms. Wise do share a child, and you have one other child, is that correct? Okay. During this period of time in the aftermath where she was texting you repeatedly, what was, without telling me the content of any message, but what was the demeanor or the affect of the messages?
from her,
Yes.
she was attacking me.
Was she saying nice things or bad things? All right. Was she threatening you? Did you threaten her back? May I approach a witness?
Yes.
Alex, I'm showing you exhibit marked as defendant's exhibit number 6. Just take a look at it. Tell me if you recognize it.
Yes.
All right. What do you recognize it?
That is sex between her and I.
All right. So are these text communications from Olivia to you and from you to Olivia as well?
Yes.
Judge offered the defendant's exhibit 6 into evidence.
Any objection?
Yes, Your Honor. I'm gonna object this to hearsay.
All right, may I see it, please?
Yes, Judge.
All right, the objection to hearsay? Or I should say the response to hearsay.
I mean, he's authenticated the text messages between him and Miss Wise.
But how's it not hearsay?
Because I'm not offering it for the truth of the matter.
Then what is it being offered for?
Freedom of.
All right, the objection will be sustained.
At some point, Alex, at some point, did it just become the smart, safe thing to do just to cut off communication with Ms. Wise?
Yes.
And when did that happen?
Completely cut off. The day I got arrested. No, the case was completely cut off, but about a week prior to the incident.
Okay. Last thing I want to talk to you about, Alex, is the apartment that Miss Wise lives in. Were you living with her?
That was our house,
Okay, I keep referring to it as an apartment. Is it a house?
the house.
Okay, I'm very sorry about that. That house, does it have recording monitor cameras?
Yeah, everywhere.
How many?
One in the room, living room, driveway, and there's a ring camera in the front door.
Okay. Let's talk about the ones in the house. Where are those located?
In the bedroom,
Was there a camera in the bedroom the day the incident happened?
yes.
Okay. Are you familiar with that camera?
Yeah.
The day this incident happened, to the best of your knowledge, was that camera working?
Was earlier that day, so I'm pretty sure it was working that night as well.
Okay. And how about the camera in the baby's room or whatever? I'm sorry, was it the baby's room?
There's a camera in our bedroom.
Okay. Who has access and control to those cameras?
Yeah.
And how is that done?
He has it all through an app.
Okay. You recall in the aftermath of all of this, her indicating that she had the cameras and a recording of what happened?
Objection leading.
Sustained.
The camera that was in the bedroom that morning, Alex, is there any reason it should not have captured what happened? Okay. And the only person who would have control over it
Objection
is
leading.
Sustained.
who has control over it?
Olivia.
Who has the ability to delete it?
Olivia.
Who has the ability to memorialize it forever so we can maybe watch it in court? That's all the questions I have for now, Judge. Pass the witness.
State.
Thank you, Judge.
Hmm.
Mr. Miosak, you're currently on probation, right? And you were placed on probation on November 24. Is that right? On the 14th of November 2024, is that right? And you were placed on probation for 2 years. And why were you placed on probation? Okay. And yes, and did you go over the conditions with the CSO? Did you sign a form acknowledging your conditions? And were you aware that you were not supposed to commit an offense in the state of Texas or in the United States? Okay. And do you currently have an offense in Guadalupe County for the offense of assault? Is that a yes or no?
I've only been dealing with Bear County.
But you got arrested, is that right?
Bear County.
Not in Guadalupe County? Okay. But you were arrested for an offense in Guadalupe County, is that right? Okay. Let's move on to the date of this incident. So how many drinks did you say you had at the bar? You were not drinking. You mentioned earlier that you were. Okay. Would it be a surprise to you if we go back to the record and say, would it be a surprise to you if we go back to the record and say that you both were drinking?
Would it surprise me?
Yes.
So that we were both
Yes. Okay. So you got to your house around 3 a.m. Is that right? And you wanted to engage in sexual conduct with Ms. Wise. Is that right?
I was okay with it. A little preoccupied on my phone at the time.
Okay. So it is your testimony that she was the one asking you to have sexual contact with her. Is that right? Okay. So what did she do when you told her that you didn't want to?
I didn't say that I didn't want to. I was okay with it. I was just on my phone momentarily.
Okay. And after that didn't happen, you mentioned that she got upset. Is that right?
That's correct.
Okay. Was she the one assaulting you first, or were you the one assaulting her first?
She assaulted me.
So you're saying that so she was the one, is it your testimony that she was the one who assaulted you in these pictures?
Yes.
And why did she assault you?
Because I said something that was rude, I was vulgar to.
Okay. So is it your testimony that she assaulted you after she got this?
This was first. I was putting my hand out to protect myself.
And you hit her back? So how did she get this injuries?
Because I put my hand up while she was being that, while she was forcefully hitting me.
Were you aware that she got a broken nose?
I was not until she sent me the medical report, the hospital report that she got.
And do you think she could have gotten a broken nose just by putting your hand up, like you just motioned?
Well, she was forcefully coming at me, assaulting me. So very possible that the contact made with the angle of me laying on my back. All I had was to go up.
Okay. So how many times did you said she hit you?
At least 5, 6 times.
Okay, and where exactly did she hit you?
So one made contact with my eye, there, ear, neck, cheeks.
Okay, I can see the injury on your eye, but how did you get that if there's nothing, if there's not a punch around it?
Because I was poked in the eye.
So you were
By her
poked
nail.
with her what?
Her nail.
Her nail. And how did she hit the side of the left side of your cheek?
Well, she was slapping me. If you can see here, there's some fingerprints here. There's red marks here as well.
So was she slapping you or was she punching you?
I believe she was just slapping me. I don't think I would have gotten her damage if she was punching.
How could you not feel whether she's punching or hitting?
I believe she was slapping.
Okay. So it's your testimony that she was the one hitting you first, and as in self-defense, you got this injuries.
Sorry, say that again.
Is it your testimony that she hit you first, and this red marks and this injuries were a result of self-defense?
That's a result of her hitting me. That's what it is. That's a result of self-defense.
But did you, okay, so right now we're looking at this, she also has a blood on her lips. Did you make this? How did she get this injuries on her lips? No, but we can see red marks and an injury, an actual injury on her lips. How did she get that? Okay.
She dried up blood on her.
Okay. And at what time exactly did you say you took the pictures of yourself?
Time exactly. I mean, it was shortly after it happened. I don't know the exact time, but it had to be after 3:30, I would say.
And where were you when you took these pictures?
I went into the guest bathroom to grab my shower stuff with my shower bag because I was leaving.
You went to where? I'm sorry, I
To
didn't.
the guest bathroom,
Okay, to the guest bed. Okay.
all my stuff.
Okay. At any point, did she ask you for ice or anything else for her bleeding?
She went to the bathroom. I heard her talking. I didn't really recollect what she was saying. My thoughts were, I just need to leave to get away from the situation.
So you didn't help her in any way after she was claiming that she was bleeding? Okay. Okay. And you were saying right now, you were mentioning something about cameras in the bedroom, right? The one that was in the bedroom where the incident happened, was it camera or was it a baby monitor?
The baby. Yeah.
Just how long do those baby monitors keep data?
I don't know how long they keep data, but as far as I know, when there's a motion in the room or sound, it starts recording.
Okay, and do you know if that baby monitor needs to have a SIM card or something to record?
I would assume so.
Did you know if the baby monitor had a SIM card to record?
As far as I know, since I bought them, it did have a SIM.
No, but at the date of the incident, did you know whether it had a SIM card or not?
I don't see why it wouldn't have.
Okay. Did you ask Ms. Wise for the recording of the incident?
No.
Why not?
Why would I ask?
Because you're claiming right now that she assaulted you. That's why. Did you
No, I
ask?
didn't ask.
No. It didn't seem important to you that if you're saying that she hit you, important to ask her for the recording?
She was accusing me of doing, really doubt that she would give me the money. So I didn't bother asking.
Okay. Okay, so when you were on your way to your mom's house and she was following you, did she ask for the keys of the house? Okay,
What she was telling me?
I didn't ask that. I just asked specifically whether she was asking for the keys. Did you have the keys of the house? Okay. So okay, so after when all this happened, how long were you and Ms. Weiss together for?
After all of that happened,
Before.
we were together over a year and a half, I would say.
Okay. I have no further questions, Your Honor.
Right, defense.
Judge, I just need to clarify a couple things. Alex, the arrest that they're talking about was on the MTR that we're here for, correct?
Correct.
All right. You ever been to the Guadalupe County Jail? No. Okay. You ever received notice from them that there's a case pending? Okay. As it stands right now, today, there is no charge pending in Guadalupe County. All right. That's it, Judge.
Any,
No, Your Honor.
you may step down. All right, defense, call your next witness.
Judge, we rest on the motion.
All right, state any other witnesses?
No, Your Honor.
All right, and then I believe defense, you had some exhibits. I didn't get a chance to see
Oh,
them.
I'm sorry, Judge.
Sorry, that's okay.
Come on.
Oh, no problem. All right. Cool. All right. So in regards to this case, any argument from the state?
Yes, Your Honor. The state has shown by a preponderance of the evidence that the defendant committed the offense of assault in Guadalupe County. We heard from the probation officer that they got the report, and that's when this violation report was submitted. Also, we heard from the probation officer that the defendant failed to submit to drug testing as directed by the court in violation of condition number 20. Also, we heard from the complainant, Ms. Weiss, and she explained to the court how she got these injuries, a broken nose, and this was after an altercation that happened between the defendant and Ms. Weiss. So, Judge, we believe that we have shown this evidence, and for that reason, we're just asking the court to revoke the probation and sentence the defendant to 1 year in Bexar County Jail.
All right, defense.
Try to keep it all kind of together. There's always been a lot about the situation that bothers me. And
Mr. Tochi,
can
you sit down so
you
can talk into the mic?
oh, yeah,
Thank you.
absolutely. The biggest issue that I have, Judge, well, of course, in any situation like this where there are no witnesses, and you have a girl with a picture like that who has blood coming out of her nose, I agree. She has dried blood on her mouth. I don't see any injury there. And there are no real witnesses. You just kind of have to evaluate their credibility, both of them. I never understood and never will why Miss Wise, who after being allegedly assaulted by Alex, doesn't do the one thing you would expect somebody in that situation to do, and that's to call the police immediately. Now, I know the court is aware and probably believes, well, there's probably a number of reasons that someone wouldn't do that. I don't understand that reaction, but I certainly don't understand the reaction to go and pursue the person that you claim to be the most fearful of. And I understand that she gave an explanation for that. But it just does not ring true to me or make any sense that she doesn't call the police. She talked about she was in a lot of pain and that her nose hurt, and clearly it was bleeding. She doesn't seek medical help. What she has in her mind and in her heart in the immediate aftermath is to still try to continue to hurt him and at some point his mother, by pursuing him 30 miles away to his mother's house where she knows she's not welcome. And then she starts to ridicule the both of them. And then she starts to threaten them about his child and her grandchild. And I really do think that that should go to her credibility. The report isn't made until a few hours after the fact, after she has tried to get Alex to come back home. She's chased him to his mother's house. And once she realizes that this isn't going to work, an allegation that he assaulted her is born. You have the pictures in front of you. And look, do I think Alex put his hand up and that and only that? No, there clearly was contact, Judge. There clearly was contact. She wants you to believe that Alex was really horny and didn't get sex. That was her testimony. And that is why he hit her. But when you look at the information that was presented to you, it was really quite the opposite. She was the one that was wanting to, they both were, especially her with some of the verbiage that she was. And it seems really, really silly that it would be born out of this, that he was denied sex and he just decides to start hitting her. Could that happen? Absolutely. But in her intoxicated state, mad, upset, could I see her climbing on top of Alex, pissed off, starting to hit him? Absolutely. Absolutely. And Alex not wanting that and reaching up because he was laying down and smacking her. This is an easy way to break a nose. I don't know. It's a self-defense technique. You probably may not be familiar with it. That'll break a nose quite easily. And Alex diffuses the situation by leaving, and she pursues and doesn't call the police and doesn't go to the hospital. And then in the aftermath of it all, now she knows, as she said, he's on probation. She has the upper hand. She has the upper hand and she knows it. And that's, the biggest part of this whole thing that I don't like is the fact that I 100% believe and cannot prove to you, I believe she has the video. I believe those video recording machines were working. They've always been working. You have the stipulated exhibit there where she tells the prosecutors, oh, I have it. Oh, I have it. And then at some point later in the future, oh, wait a minute, it got recorded over. The interview was on April 7th. The incident was February the 8th. If that video, if that audio, or whatever it is you had was that important, you are not going to let that happen. That is literally the smoking gun. She's the only one with control. She's the only one with access. She's the only one that can delete, record, memorialize, or do whatever she wants. And we don't have it. And I absolutely believe the recording device was working and she deleted it. I could kind of go on and on about her behavior, but there just is no reason for Alex just to go off over sex and do that. I understand that the burden of proof is really, really low. If the court finds it true, I certainly hope that the court doesn't lock him up for a year, Judge. He has children, he has gainful employment. I believe that Ms. Wise relies on his employment to help support Harlow, their child. And so I believe that it happened a lot more likely the way Alex told it versus her credibility. I find his credibility to be greater than hers. And I hope the court sees it that way as well. I'm asking the court to find it not true. If you do find it true, Judge, I'm asking you not to put him in jail for a year.
All right. Court is finding violation of condition 1 and 20 true. If y'all could do a trial court certification of defendant's rights to appeal for the court. All right. As previously stated, the court is finding violations 1 and 20 true. Court is going to find the defendant guilty, grant the motion, and revoke. Does anyone wish to speak to punishment? The state is asking for a year. Defense, what are you requesting?
I mean, Judge, obviously not that. I mean, the court can continue him on supervision. The court has a ton of options that can be utilized.
We're going to continue him.
I mean, well, obviously I would ask for a very low term of jail, perhaps 30 days, Judge.
All right. Does anybody want testimony from probation as to how he was doing while he was on probation?
Well, I believe we already have that. Exemplary was the report from both POs. They had no issues whatsoever. I mean, that was my recollection, that they had no problems with him at all.
I just wanted that to be addressed because now we're at what would be appropriate punishment with the revocation. So
okay.
If anyone wants to speak to that, for the record, you can. I do recall what was said by the witness.
Are you talking about Vashon, Judge? I'm sorry.
Oh, no. It's if you want to ask Ms. Abrams some questions, or if you want the court to go on previous testimony from the probation officers who were supervising your client, I can go off of that as well.
Yeah, I'm comfortable with that, Judge. And that was the very reason that I asked those questions, because I figured we might get to this point. And I just wanted the court to understand that up to this, he would be, as I would describe, a model probationer.
All right. Anything else from the state?
No, Your Honor, other than the 2 violations that he committed, even though he was doing good on probation, he still committed those 2 violations. So that's all.
All right. What the court is going to do, there's an affirmative finding of family violence. There's previously, I think I had ordered a no contact with Shelby Schultz unless it was through the parenting app. Now I'm going to change that to no contact with Shelby Schultz. And does everybody agree that was the previous condition? Only contact through the app?
Yeah. I believe it was, Judge. I didn't represent him on the previous case.
I just wanted to make sure.
Yeah.
All right. So there'll be no contact with Shelby Schultz. And then the court is going to sentence you to 180 days in the Bexar County Jail. Give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Do you understand it and sign it?
Yes, she asked your question.
Sorry.
Did you review the Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes. Yes, Your Honor.
They haven't requested it, so. All right, because this is not a plea bargain agreement, you do have a limited right to appeal. That right to appeal is as it relates to the allegations and the motion, not the fact that you were on deferred adjudication. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. And counsel, this is your document. And counsel, if you want to check with the clerk on the days he has in. All right, thank you. All right, who's next? Who's ready? Yes. All right, on this case, I mean, I've already informed defense counsel, you all waited too late to file a motion to withdraw. We're at jury trial stage, so.
Well, Your Honor, if I may.
Yes.
We were hired on this case in November. Mr. El Gadrab failed to appear to a hearing back in November.
as.
Because he was currently in a hospital. We were waiting for documentation and documentation was provided.
Yes. And documentation I don't believe documentation was provided, Your Honor. We attempted to reach out to Mr. Elgadra, but there was no communication returned. We lost communication as a courtesy for him to attempt to reestablish communication. We waited a couple of months. We filed a motion to withdraw in January. I attempted a few times to address that with the court, but because there was an active warrant, that was not considered until he was arrested and brought before the court. And the first opportunity we've had to address that filed motion back in January in front of the court was today. So that's why the motion to withdraw is being urged today in this matter.
When were you all hired for this case?
When?
When?
November 11th, I believe. Yeah, it was November 11th we were hired. We filed a notice of appearance on November 11th, which was a holiday.
Okay, so you all filed it on November 11th of 2025?
Yes, sir.
All right. So he had previously had an attorney representing him before you all were hired. So this case is going to trial and you're his attorney. So y'all are going to be back tomorrow.
I never request for the trial either, man. I never request for trial either.
All right. Well, we'll see what happens tomorrow.
Your Honor.
Yes.
Like I said, Mr. Elgadrab failed to cooperate and maintain adequate communication with us. He, at that point in time, severed any sort of attorney-client relationship at that point. We've had no opportunity to address the case with him, talk about any possible defenses. Additionally to that, we learned that he is not a U.S. citizen. I have not had the opportunity to discuss matters with him in relation to us at D11.
I'll see y'all back tomorrow for jury trial on April 29th, and whatever y'all need to discuss with him, discuss with him. Because what I do know is he had been represented by an attorney at the beginning of May of 2025. Then you all were hired and now you all went off. I mean, his trial is upcoming and he's saying that he doesn't want a trial. So I'll see you all tomorrow. All right, who's next?
Your Honor, if I have,
Who do you have?
but I don't have any more, Your Honor, but I have more to present to the court as to why. we're not
Sure,
going-
we can present more. All right, the court is calling 2025 CR 004768 State versus Mahmoud Al-Gadrab. If you'll come back. Can I have parties announced?
Lauren Espinoza for the state.
Mario Moreno for the defendant, Your Honor.
All right, and are you Mr. Al-Gadrab?
Yes, ma'am.
All right, the court will note for the record, the defense off the record told the court that they were seeking to withdraw from the defendant's case. The defendant previously had an attorney, May 2025. Defense counsel was hired according to the defense, November 2025. We are now here for jury trial, and the defendant has been in custody since, I believe, was he placed in custody?
Yes, stayed in here in the first.
I'm sorry? March 8th. He's been in custody since March 8th of 2026. And so this is scheduled for jury trial today. And I'm sorry?
I was not in this county.
That's okay. You were in Hardin County?
Yes.
Yes, since March of 2026. This case is set for jury trial today. The case was previously set for jury trial on January 7th, 15th, 2025. And then it was reset for jury trial on November 12th, 2025. Defense counsel was hired. And when that case was set for jury trial on November 12th, 2025, it was set on September 15th. I'm sorry, for the record. It was set on September 15th, 2025 for jury trial and a plea deadline date on November 12th, 2025. And then defense counsel was hired in November 2025. And so this is set for jury trial. Defense, you wanted to place something on the record?
Yeah, sure. And I was not aware that we weren't previously on the record, so I will
That's okay.
restate everything I had previously said. So Mr. Elgadrab did hire our firm as a Barton and Associates law firm back in November 11th, 2025. There was a jury trial scheduled at that time, but Mr. Elgadrab did not appear for that date. We were informed that he was in the hospital and would provide, and this was not information that was provided to us directly from Mr. Elgadrab. We were told by an associate that he was in the hospital and would provide details to provide to the court as to potentially excuse his not appearance on that day, but we did not receive that information. We lost contact with Mr. Elgadrab, and he failed to maintain and cooperate with our law office. Thereafter, we, in order to give him some sort of benefit of the doubt and give him some chance, we held off on a motion to withdraw until January of 2026 because we failed to establish contact with him at that point. I attempted several times with court to present a motion to withdraw earlier in the year after it was filed on January 26th. But the court refused to hear that motion while Mr. Elgadrab had an active warrant and was not in custody. So it wasn't for any lack of our firm or the defense attorney's attempt to obtain an alternate attorney for Mr. Elgadrab at that point. We were told that it would not be entertained until he was in custody and in front of the court. And the first opportunity that he was in custody or in front of the court was today. And so that is why we're attempting to withdraw at this point in time when he was set for trial. When I attempted to schedule it for a motion to withdraw hearing prior to today's date as well, but I was unable to get that scheduled due to court scheduling over the past couple of weeks. Mr. Elgadrab has had little to no contact with our office to prepare for trial. Additionally, he is in need of a Padilla letter with admonishment from an immigration attorney. I've had no communication regarding that with him to prepare for that or to get an understanding of what that might look like. He's had no admonishments from an immigration attorney about his potential consequences. We are not prepared to accept any offers or prepared to go to trial due to these reasons. If I was to go to trial without this information on Mr. Elgadrab, it would be ineffective assistance of counsel at that point. I think it is in Mr. Elgadrab's best interest at this point, because the attorney-client relationship has been severed due to his cooperation with our office and inability to communicate, that we be withdrawn, he be appointed an attorney by the state, and that he have an opportunity as well to get potentially an admonishment from an immigration attorney for Padilla, so that he could understand what his potential consequences are in this case. This is a case involving moral turpitude.
Yes, and with cases involving moral turpitude, if you are not a citizen, then if you are found guilty, if you enter into a plea bargaining agreement and it's a crime of moral turpitude, you're deportable. Yep, the motion to withdraw is denied. You all need to discuss. If you don't want to talk to him, what's going to end up happening if you're going to go to trial with an attorney you have not talked to. So, thank you. All right, I'll see you all tomorrow. All right, who's next?
I have,
Ethan J. Castillo. Court is calling 2025 CR 007-447 State versus Ethan J. Castillo. Can I have parties announced?
Or Espinoza for the state.
Let me bring up Mr. Castillo to my right.
And are you Mr. Castillo?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Ethan J. Castillo who was placed on deferred adjudication in 2025 CR 007-447 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams on October 23rd, 2025 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1, on or about the 12th day of February 2026 in Bexar County, Texas, the defendant Ethan J. Castillo committed the offense of burglary of vehicles in violation of condition number 1.
How do you plead to that? True or not true?
It's true.
Violated condition number 4, in Bexar County, Texas, the defendant Ethan J. Castillo did then and there fail to report to the supervision officer as directed for the month of January 2026 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State will waive the remaining alleged allegation.
Any objection to the waiver?
No.
Did you understand by pleading true to violation 1 and 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violations 1 and 4?
Yes, ma'am.
Court will find 1 and 4 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to deny state's motion, alter and amend for SATIF.
All right. Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right. And what is happening with the new number 1?
The new number 1, Judge, was already closed out and pled on.
Okay. All right, the court will deny the motion, alter and amend conditions to include and the following in custody. Status, and if not accepted, I'm sorry, let's do felony drug court referral. Is he eligible for that?
Judge, it was already a felony drug court referral, but we can do another one.
All right, so in custody, do a referral to felony drug court. If not accepted, then SATIF, and he's to remain in custody until accepted into felony drug court or SATIF. All right, is there anything else?
Nothing, thank you, Judge.
All right, thank you.
Thank you, Judge.
Jeffrey Dollar. Court. Okay, this is a PSI, am I correct?
It's a sentencing. It was a 2-week reset for sentencing. You gave us the option of a PSI
Yeah.
or no PSI. We chose for the more expedited approach.
No, it's just that there's a file stamp on here that says it's something else, but okay. All right. 2025 CRs 007775 State versus Jeffrey Dollar. Could I have parties announce?
Lauren Espinoza for the state.
Christopher Ramos for the defense.
And are you Mr. Dollar?
Yes.
All right, so in this case, the PSI was waived. You entered a plea. The court found there was sufficient evidence to find you guilty. The court found you guilty. According to your plea bargain agreement, punishment is to be assessed at a cap of 10 years in the prison. There's a $2,000 fine. There are no applications. This is run concurrent with 2508157113 CR out of Medina County.
Yes.
Any witnesses from either side?
None from the state, Your Honor.
Not witnesses, just a few exhibits for the court as evidence.
All right, any objections to the court reviewing the documents?
For the benefit of the record, my client, while in jail, has undergone various programs. Specifically, he's attended 8 sessions of AA. He's attended 10 sessions of substance abuse curriculum. He's completed the peer mentor program. He's participated in the MAT program, and he's completed 21 sessions of Narcotics Anonymous. We're asked court to take these certificates and these completions into evidence as part of the record.
All right, the court has reviewed the documents and the court will take that into consideration when passing sentence.
Yes.
And all we have left is just argument, Judge, so we'll close our evidence.
All right, state.
Your Honor, we're asking that you sentence Mr. Dollar to the cap of 10 years. Mr. Dollar does have criminal history. This history does not only stem from drug cases, but also firearm possession, as well as victim cases such as the UUMV and then the instant case here as being a robbery. Mr. Dollar was sentenced to 46 months confinement with 3 years of supervised release federally, as well as 21 months with some supervised release subsequent to that confinement. Both of those federal probations resulted in revocation. Additionally, he also did straight time in both state jail and TDC in Bexar County and Amarillo in Potter County, Texas. Because of his criminal history, Judge, I believe that Mr. Dollar would not be a viable candidate for probation. He has shown in the past that he.
I'm sorry, there's no application.
I'm so sorry.
That's okay. It's been a long day. It's fine.
Because of Mr. Dollar's prior criminal history and his subsequent revocations, I don't believe that he would be a viable candidate for a sentence less than 10 years because he's already done a significant amount of time and continues to put himself in situations and make choices that show that he is not a law-abiding citizen. So because of that, Judge, we'd ask for the cap of 10.
All right, and defense.
Judge, we're going to ask for a sentence on the lower end. As you can tell from the reports, so to be clear, he knew this individual, the complainant, from a prior dating relationship. She maintained possession of an item that was his. He went about this absolutely the wrong way and the illegal way, but he went to her vehicle to try to retrieve it.
She intercepted him, and in the process, he used physical force against her. It's in going over the evidence with him, and showing him how he went absolutely wrong. In reviewing the evidence, he agreed. He realized that he messed up. He took ownership of that, of breaking the law. And we're asking the court to consider the following, that I'm the second attorney on the case, but he met with me. He was forthright. We looked at the evidence, and after reviewing the evidence, we approached the court and set up this plea negotiation. And I'm mentioning that he didn't want to belabor this with a trial. He accepted responsibility immediately. So we're asking the court to sentence him on the lower end of the range because he's taking responsibility. He went about, this was not necessarily a random act. He went about trying to get some property absolutely the wrong way, but that's how this action unfolded. So for that, Judge, we're asking for the lower end.
All right. The court, as previously stated, has found you guilty. There's to be no contact with the complainant. The court will order the therapeutic community. This is run concurrent with 2508-15713 CR. That's the case out of Medina County. There's a $2,000 fine, time and money to run concurrent. Credit for any time served, no residing in households with minors, no unsupervised contact with minors, and the court will sentence you to 9 years. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. You understand?
Yes.
All right, and I appreciate the fact that you were using your time wisely to try to better yourself. I took all of that in consideration, okay?
Thank you.
All right, thank you. Have a good one.
Thank you, Judge.
Thank you.